Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. Hello. How are you guys doing? Good morning, good afternoon, good evening, wherever you are coming in from. I hope that you are having a good Wednesday. I had to put that in my brain, like today's Wednesday, because in the past I haven't been live streaming on Wednesdays. It's been Mondays, which I still am for Classic Trial. I've got members only live stream on Fridays, and then Tuesdays and Thursdays I was doing legal tea, latest in the law. I kind of merged those together into one live stream on Wednesday so that I have more time to do more upload videos, right? More pre-recorded stuff, so that I can kind of piece things together in a way that's a bit more digestible so that people can kind of get the information in a smaller package, I could say. So, but something like this is it's just so fun to pick apart on a live stream. So, yeah. Anyway, so this is a good one for a live stream, right? So, let's see here. Let me say hello to some folks in the chat. Where's everybody coming in from? This is one of my favorite parts. Secret McSquirrel, thank you so much for becoming a YouTube member again. Welcome back to Bite Club. I know you've been struggling with you had a PayPal issue there for a bit, but welcome back to Bite Club. Let's see. Living life with and singing songs. Mallory says hello from cold Utah. Going to be inside for the day. I have been off my walks. I do, and I hope to get back into that. Thank you for all you do. Keep up the amazing work. Love the content. Thank you so much. Thank you, and thank you for watching, right? For participating, and yeah, I hope those walks. I hope you're able to get back into those. Annalie says hi from Sweden. We've got Rachel McGowan, hello all. Good morning from Florida. Mary Ann Williams, good morning from a chilly Vegas. Sunshine's Badges and more says hello from Nova Scotia, Canada. Caitlin Klein, good morning from snowy Minnesota. And we've got a bunch of people coming in here. Let's see. Okay, we've got Lulia Tvigun, I think is how you pronounce it. Hi from Moldova, sending you Eastern European love. Thank you so much. We've got Mantha Johnny's got some love for Holmes on the chair back there. Yes, he is. And by the way, you can't see it from there, but he is wearing the most dapper plaid Christmas bow tie. Maybe he'll come up and say hi at some point and you guys will be able to see it, but it is chef's kiss. Sonia Yurch, hello from Croatia. Hello. Gwendolyn SS from Michigan. We've got, is it Kanal Peja from Poland? I'm so sorry if I completely butchered your name. Jenner G says hello from Sticklerville, New Jersey. Jessica, morning from New Jersey as well. Bethany Joe Chamberlain, good morning. Having my second cup of coffee. Hey, from Portland, Oregon. Good morning. I'm always up for that second cup of coffee. B says Germany says hi. Venegour 10, hello from Glasgow, Scotland. Jana Brannon, good morning from sunny Arizona. We've got Cheryl C saying hi. We've got Shireen saying hello from Yorkshire. Janet says hi all from UK. Hez 01 from Alberta, Canada. Anna B from Portugal. David Batalor, hi from UK. Vicky Pazdur, hi from Oklahoma. Oh my gosh, we've got so many folks in here today. I love this. I am absolutely loving this. I know we've got a lot of interest in today's topic. So we are going to get right into it. But before we do that, and I just, oh God, I want to keep going through where everybody is coming in from, but I guess we've got to get into the subject, right? But before I do that, I do want to pull up the memberships once again, because I found out today that my video on Courtney Clenny that I put out recently, that was about some stuff that came out in a recent hearing. If you're not familiar with the case, that is the OnlyFans murder case. She killed her boyfriend. That's not disputed. The dispute is whether it's murder or self-defense. Killed him with a knife. Anyway, I'm not going to go into any more detail, because that's precisely the reason why that video got demonetized. And so I cannot really make any money off of that. So, realistically, if I it's not going to discourage me from going more into that topic, because I am very interested in that case. I know a lot of other people are as well, and I plan on covering the trial as well. I anticipate that's probably going to get fairly demonetized as well, just because of the subject nature, or subject, the nature of the subject, I should say. So if you do want to support the channel, it's super helpful to me, so that I can continue to cover these topics and not really worry about that. So if you want to become a YouTube member, a supporter on Local, support on Patreon, all of those links are in the description below. Yeah, that would be lovely if you guys want to, and if you are in a position to do so. Otherwise, no worries. I love the fact that folks are here and they're watching content, and engaging nonetheless. Also, Mark, oh my God, you totally, Mark, you gave me the pronunciation for your last name last time. Mark Fedes. I don't know. I'm so sorry. I remember you correcting me, and I forgot what the correction was. I'm so sorry. This is hi from UK. Can't wait to hear your take on this trash. Well, we'll get into it. Well, I'll give you a little bit of my thoughts in just a second, because I read through most of it. I intended to skim through all of it so that I could know basically what the arguments are. But as often happens with me, I will be reading through it, and then I'll look at the cases that are cited, and I'm like, oh, that's interesting. Let's take a look at what they cited. Does it actually support what they say it supports? Anyway, and then I get into a number of different rabbit holes. And so that made things a little bit slower getting through it ahead of time. So I went through, I would say, most of it. And so I do have some thoughts. Marie Araujo says, hello from Rio de Janeiro, Brazil. Good morning or afternoon in Rio. I think you're a little bit further than East Coast, so maybe, I'm not sure exactly. But anyway, thank you very much for the super chat. Very generous of you as well. Alrighty. Okay. The brief, or the response brief, I should say specifically, right? Because this one is not in Amber Heard's appeal. This is Amber Heard's response to Johnny Depp's appeal brief. So all of the arguments that we went through, that one was actually a VOD on my channel, because it was so neatly, Mark Fittis. Okay. Thank you. I am so sorry. It's the I and the E that always trips me up. But I'm one to talk, because my name is spelled Alyte, and Alita. I don't know. Anyway, so okay, one of these days I will get it. Thank you. Hopefully next time I will get it. Okay, so all right. Okay. So this is like I said, this is a response to Johnny Depp's appeal brief. And I was just saying that this was one of those that was packaged so neatly, that it was kind of perfect for a simple VOD to go over and to give my thoughts on it. This one we're going through, we won't exactly go line by line through the entire thing, because it's like 58 pages again. So we're going to skip some portions, particularly the part that's like the statement of facts, when Amber Heard's like, on May 16th, 2016, he abused me, and all this kind of stuff. So, we basically know what she's going to say, because it's the same kind of fact pattern that she's been saying this entire time. She's definitely not going to give that up at this point. And that would certainly, I would not expect her to, as a lawyer looking at this, right? Because that's her position. B says, your next challenge is to say, I think it's Lockmailken. Little two, the CH sounds like dislodging some slime when you have a cold. Okay, so Lockmailken, maybe. Thank you for the challenge. I probably butchered that. um, okay, let's actually get into this, shall we? Okay, so here is the appeal brief response right here. As you can see that Johnny Depp is the appellant. That means that he's the one that actually filed the appeal. And then Amber Laura Heard is the appellee, or if you, or if you're Elaine Bredehoft, it's Laura Amber Heard. Anyway, those mistakes can happen. Okay. So, and then the table of contents is a pretty good way to kind of go through the basic arguments here. So first, this really, there are a number of ways that they could have have organized this, right? Like when we're talking about this kind of brief writing, there's a number of strategies. You can, I mean, ideally, in any kind of a case, you want to organize it so that your strongest arguments are up front. But what they did here was that they just kind of tracked Johnny Depp's order of arguments. So he talked about the independent contractor theory first, then the actual malice argument, and then all that stuff. So every single argument that he went through, they went through to respond to his on like basically a 1-to-1 basis on that front. That's not a terrible way to organize things because that makes it very clear that you are responding to every part of the initial brief. But I would say that the first argument is not their strongest in terms of there as in Amber Heard's. It's not the strongest argument here. And we'll go through why that is. Now, from what I've read so far, is this a terrible brief? No, I don't think so. I don't. Sorry, I always do this, and part of it is because I never really sit exactly in the middle. So because I like to show the chair in case Indy decides to not sleep on the floor like she's doing right now. Anyway, so okay, so it's not a terrible brief. I will get that out up front. It's not, one that we can kind of pick apart and just make a total mockery of it because it just doesn't make sense at all. It does make a lot of sense. They do make their best arguments. I think, there are some, some points that are stronger or weaker than others, but it's not terrible. I will say that. Okay. And also, before it gets away from me, Cheryl M., thank you so much for becoming a YouTube member. Welcome to Bite Club. Wonderful, wonderful to have you here. And thanks so much for supporting the channel. All right. Okay. So we're going through here. So first they went through the independent contractor theory, and then they go through the actual malice theory, saying that he waived any argument about the summary judgment issue, which is probably their stronger argument than the independent contractor one, I will say. And then they go into the opinion argument. So where they say that Adam Waldman's statements were a matter of opinion, not a fact statement. So therefore they're not the basis of defamation, right? So that is an argument. If you can convince the court of that, that's a strong argument, right? Because that is the truth, right? It has to be a fact-based statement in order for it to support a judgment of or a liability for defamation. Okay, and then they go through talking about the jury instructions, about independent contractors, and then they go through the context argument, right? Because Johnny Depp in his appeal brief said that in order for sorry, let me back up for just a second. I'm getting ahead of myself. Johnny Depp said that a defamation statement has to be shown in its proper context in order to find for that it's properly defamatory. So they're saying that it was proper for all of this other contextual stuff to be kept out. So we'll go through that as well. All right, this is all of their table of authorities, all this case law, yada yada yada. Statement of the case. We can scroll through that. We all saw the trial, right? I guess The only part that was kind of interesting to me was this part following Mr. Depp's suit arising out of Miss Heard's op-ed in which she described public backlash faced by women who alleged violence. Miss Heard filed a counterclaim for defamation seeking redress for reputational harm caused by the statement. It's funny because it's like this is an example of actually decent brief writing, right? Because this is placing this is describing what happened and describing it, continuing to frame it in the way that is most beneficial to your case. Now, we look at the statement and we're like, that's not what that was about, right? And that's not what he was suing for, right? Because he was suing over these statements about him that were implying that he had abused her, right? We all know that. But this is an example of how, when you are pursuing legal action, you've got to maintain your position going through. And so this is a way of saying like describing the op-ed and saying like, well, this was where she described, these policy issues and all this kind of stuff. As opposed to she talked crap about Johnny Depp and used him for defamatory purposes and all that other stuff. So anyway, but other than that, we can basically scroll through here. We can skip through a lot of this, and then okay. Yeah. So this is the Mr. Depp's intent to retaliate against Miss Heard. It gets, it gets very colorful, talking about let's drown her before we burn her, those fun texts, that kind of stuff. Okay. Sorry. Continuing to scroll through, and here, is this the argument section? Oh, no. Okay, sorry. I was taking some more notes here. So this actually, okay, here we go. Here is the argument section. So we can, okay, let's see. Yeah, no, this will work. All right, we can start from here. Mark Fittis, thank you for giving me another opportunity to to get your last name right. Says, I see Ben dropped the SA allegations. That was probably I wasn't paying attention to the other stuff outside of what was highlighted, but could be. I can't remember exactly. So thank you for the super chat. Okay. So this is the first argument here, which is about the independent contractor theory. It says Mr. Depp's independent contractor theory is inapposite, and whether Mr. Waldman is his agent was a question of fact relating to assignments of error A1 and 2. So what their point was is that, this being a question of fact, that's up to the jury, and so this is a jury issue basically. Okay, let's see here. Okay. So it says a plaintiff who is, so it starts with the standard of review. It was in the, Mark Fitty said it was in the statement of the case. Oh, okay. Yeah. Okay. So the standard of review first talks about the standard that the appellate court is supposed to use in looking at this specific issue. So you'll see that this kind of a paragraph multiple times throughout this brief, because it's talking about each different issue. You can have a de novo standard of review. Basically means that the appellate court is able to start with a blank slate and use their own analysis of the issue. Then there are other issues where they are supposed to give a lot of weight, a lot of discretion to the trial courts. So this is depending on whatever, like I said, whatever issue is at hand. Okay, standard of review. A plaintiff who is armed with a jury verdict approved by the trial court stands in the most favored position known to the law. When a trial court has refused to strike a plaintiff's evidence, the well-established standard of appellate review requires this court to determine whether the evidence presented at trial, taken in the light most favorable to the plaintiff, was sufficient to support the jury verdict in favor of the plaintiff. Whether the concept of an independent contractor applies to this case is a question of law that is reviewed de novo. So like I said, that means that this court is going to be reviewing this specific issue from scratch. They don't have to give any weight to the judge's determination in the court down below. And whether Mr. Waldman was acting as Mr. Depp's agent when he made the statement was a question to be resolved by the jury. And the jury's finding should not be disturbed on appeal unless it is plainly wrong. So what they're doing here is they're basically just distinguishing between two kind of sub issues within the independent contractor issue, right? Because it's whether there's this question of whether attorneys should be classified just like right offhand in a defamation situation, whether attorneys should be classified as independent contractors or whether they should be classified as, or whether they can be classified as employees. Um, and then there's the question of whether in this particular case, Adam Waldman fits into a an agency kind of role, right? Like whether the elements of vicarious liability were actually met in terms of the evidence that was presented here. Okay, part B. Mr. Waldman can be both an independent contractor and an agent. Mr. Depp claims that Mr. Waldman is, as a matter of law, an independent contractor rather than an employee agent and is thus not liable for his statements to the press. Agency is defined as a fiduciary relationship arising from the manifestation of consent by one person to another that the other shall act on the behalf and subject to his control and agreement by the other so to act. When an agent commits a tort while acting within the scope of the authority, the principal is liable. And this is, I mean, this, when you read a sentence like this, it's important to note that like the more detail they give, the more those are the more you should consider those to be like sub requirements, right? Because it's not just when an agent commits a tort. It's when an agent commits a tort within the scope of his authority. The principal is liable. In other words, like if let's say that somebody has let's say I hire someone to paint the outside of my house, right? And then while they're painting the outside of my house, they decided to go over to the neighbor's house next door and rob them. Am I responsible for that? Because I paid them to paint my house? No, because that's outside the scope of what I wanted them to do, right? And there's a number of elements that would be, or a number of factors that would be looked at in terms of like, whether even if it's not specifically in the contract, it's like, does that benefit me for them to go and do that? Does that, there's a number of things to look at, but so something like this that's very specific, like it has to be within the scope of that employment. That's an important aspect here. Okay. All right. Well, keep going through here. Okay. Let's see. Da, 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 da. Or, okay. So, and this is citing to Jefferson Standard Life Insurance, which says explaining that principal is liable for the torts of his agent, even though the principal did not authorize or justify or participate in, or indeed know of such misconduct, or even if he forbade the acts. And then there's Fuse v. Riverside, which recognizes that defamation may be based on statements made by an agent. I mean, that's undisputed, right? Neither side argues with this. Johnny Depp, his team does not argue with that prospect. An agency relationship can arise in any circumstances and is not limited to the employment context. Well, this is also true. Let's see, for example, Thomas v. Wingold, affirming jury verdict against a mother arising from a motor vehicle accident caused by her son, who was acting as an agent when the accident occurred. In the employment context, a person's status as an independent contractor precludes the existence of an agency relationship. The doctrine of respondeat superior imposes liability on an employer for the negligent acts of its employees. If, however, the negligent acts were performed by an independent contractor rather than an employee, no master-servant relationship exists between the contractor and employer, and the employer is not liable for the negligent acts. The concept of an independent contractor, however, does not apply in all agency contexts, nor does establishing an individual is an independent contractor defeat the possibility of any agency relationship. And then it cites to so this is an interesting point right here, though, because this point at the top of this paragraph here about the court saying you're either an independent contractor or you're an employee, and if you're an independent contractor, The person that hired you is not responsible for you doing the wrong things, right? This is pretty clear. This quote right here, I'll read it again. The doctrine of respondeat superior, meaning vicarious liability, being held responsible for something that somebody else did, imposes liability on an employer for the negligent acts of its employees if, however, the negligent acts were performed by an independent contractor rather than an employee. No master servant relationship exists between the contractor and employer, and the employer is not liable for the negligent acts. In other words, they're saying here, it's super clear here that they're saying if someone is an independent contractor, then no liability. This next sentence right here seems to undercut what this says here. But this part that I just highlighted in light blue here is from the Virginia Supreme Court. This next sentence that's highlighted in pink down here about the concept of an independent contractor does not apply in all agency contexts. This is citing to Petrovich v. Share Health Plan of Illinois, Inc. That should tip you off. This is from Illinois. This is not Virginia case law that they're relying on for this right here. And then you go through, I mean, at first when you don't look at these specific cases and you kind of just look at like what they say, it looks pretty damaging to Depp's case here, right? Because they say vicarious liability may be nevertheless imposed for the actions of independent contractors where an agency relationship is established. Then you've got this case, which is from Texas, that says agency and independent contractor status are not mutually exclusive. I mean, here's the thing. Here's a core concept of any kind of legal writing, right? Whether it's at the trial court level, the appellate level, Supreme Court level, an attorney is going to use the strongest case law that they can find, right? Like that is what these attorneys get paid the big bucks for, right? Is taking the time to find these cases that support your position. So the strongest ones that you can find for this particular case right here in this brief are going to be from the Virginia Supreme Court, because that is binding on the appellate court here, on this court that has to make this decision in this case, right? So if there's a Supreme Court case law that says something pretty strongly and you're trying to undercut it with other case law, and you're using, not only is it not Supreme Court cases from any state, but it's also from other states. So it's not binding on this court. And it certainly is not something that is going to sway this court from being persuaded away from the Virginia Supreme Court, because they have to follow the Virginia Supreme Court. So the best that they can hope for with this particular point here about there being this weird, like gradient, I guess, that you can have between an independent contractor and an employee. The best that Amber Heard's team can hope for with this particular point is that some sort of like an outer edges kind of like an extra extrapolation on what it is that the Virginia Supreme Court says. In other words, like it can't conflict with what the Virginia Supreme Court has said here in this particular part. So I hope that makes sense to you guys here. But that was a really interesting thing here, is that right off the bat, all of their arguments for this part right here are all they're from Illinois, they're from North Dakota, or sorry, not North Dakota, this is Texas, Northern District of Texas. They're from Utah, they're from Oklahoma, they're from the 10th Circuit here. These are not binding on this court. So I do see a question in the chat from DeGeneres Queen, says, that's pretty sneak. No, hopefully Ben Chu points this out. It destroys the argument and Amber's team's credibility. No, I mean, it doesn't destroy their credibility, because this is an example of what to do when you don't have really any law out there that is super supportive for your case. You've got to make the best possible argument, right? So they have this responsibility. In fact, the attorneys in this case that wrote this brief, they have a responsibility to zealously advocate for their client. If even they might even be sitting there thinking this is full of shit. you know, there are, um, I think it, let me put it this way. It, it's going to be impossible to find any attorney that says I have fully believed in every single argument that I have ever made to the court. And it's not to say that lawyers are being deceptive. It's that they have to make the best argument they can make, even if it's not a good argument. It's just the obligations of the job. Um, and we've also got Family Man Donnie says, when you cite case law, can it come from any state or only the state where the trial is taking place? It can come from any state. Let me make that very clear. So there are two different levels of support here when we're talking about case law. And it's not just case law that you can draw from. You can draw from statutes, you can draw from case law, you can draw from treatises. You'll see some citations in this brief to the restatement of agency. That is a way of getting support. But the strongest, there's a hierarchy of support here. The strongest is going to be the case law that is binding on this particular court. So for this court, what's binding is appellate case law that is from this specific court here, from this district, and then also Virginia Supreme Court and the United States Supreme Court. Any of those court opinions are going to be binding on this case. So in other words, they're going to say we have no choice but to follow their reasoning and their conclusions, because otherwise that's going to be a quick way to get overturned on appeal from this court. Now, either side can pull from case law from other states as well. Johnny Depp's brief does that too. But what they do in in Johnny Depp's brief that's different is they say, hey, we know that the Supreme Court of Virginia has never analyzed the issue of, whether attorneys as a matter of law are always going to be independent contractors. There's no case law that we have been able to find that touches on that issue. In other words, if this goes to the Virginia Supreme Court, this specific issue, it would be a matter of first impression there. So it's the first time they're looking at it. It's the first time they're sort of like garnering some thoughts on it. And so what happens when you encounter a situation like that is you're going to have to draw from other courts, other jurisdictions to say, this is what this court said, this is what that court said, and this was their reasoning. But the thing that's different about that is that is a persuasive authority. So you have to persuade this court to side with you, to adopt the authority that you are citing to. Some cases, some states will tend to align more in one direction versus another direction. So sometimes you can kind of guess how a court might lean if they are to look at this sort of persuasive authority. But where you have like a situation like this, where you have persuasive authority, which is the other states, versus binding authority, there's no argument. The court's going to follow the binding authority. So I hope that makes sense as well. Let me get something right here. Anna B became a YouTube member. Thank you so much for becoming a YouTube member. Welcome to Bike Club, and thanks so much for supporting the channel. Really appreciate it. HP, thanks so much for your super chat. Says, who chooses the points of appeal, the client or the lawyer? This is generally going to be, this is much more heavily going to be the lawyer here, because this is all like very heady, brainy kind of legal argument. Trial court trials tend to be much more theatrical, we could say. And, so I don't know, not to knock the trial court level, right? Because there's certainly a lot of law, but this is all like very into the weeds kind of legal argument. So this is really going to be the lawyers here that are running this series of arguments. Okay. All right, let's see here. Okay, so we can just kind of skip through the rest of this because, like I said, this is all persuasive authority that is not going to convince the court, in my opinion, because it looks like it contradicts with Virginia binding authority. So then it says Mr. Depp is incorrectly importing the concept of an independent contractor, which negates an employer-employee relationship, a specific kind of agency relationship, to all agency contexts. In doing so, he has presented a false dichotomy by arguing Mr. Waldman is either an independent contractor or an agent, but the two are not mutually exclusive. And so again, this is there's a footnote here talking about the logical fallacy of the false dichotomy, that it's based on the false premise that only two mutually exclusive options are available, when in fact the options are not mutually exclusive, or there are more than two options. In other words, it's like telling a 3-year-old toddler, you can choose the pink shoes or you can choose the white shoes. Ignore all the blue and green and yellow shoes over there on the other side of the room. But that's not what's happening here, because this is, the like I said, the authority for there not being this mutually exclusive relationship between independent contractor and employee is based off of case law that is not binding in Virginia, and it seems like it doesn't fit with the reasoning that the Virginia Supreme Court had in that. And at the same time, this is I don't see how Adam Waldman's relationship with Johnny Depp is not in either like a type of employment relationship, right? Either an employer-employee relationship or an employer-independent contractor relationship. I understand that it can blur the lines, right? You can have somebody that is kind of a utility guy, so to speak, right? That does a lot of different things for somebody. An attorney can certainly be someone like that, because especially if they are particularly business savvy and all kinds of stuff. So you can absolutely have someone that who has multiple roles. But in this particular case, I don't see how this is not some kind of an employer-employee or employer-independent contractor relationship. But anyway, let's go on. Because Mr. Waldman can be both an independent contractor and an agent, even if Mr. Waldman is an independent contractor, it does not preclude Mr. Depp's liability for Mr. Waldman's defamatory statements to the press. As a result, subpart A of the first assignment of error and the second assignment of error do not assert any grounds for reversing the judgment of the circuit court. No, I don't agree with it. Because like I said, the authority that they're resting on is not good. So like I said, uh the independent contractor argument right off the bat has in my opinion, it has a bit to be desired. If you're looking at it from Amber Heard's perspective. Part C. The circuit court properly denied the motions to strike because whether Mr. Waldman made the statement while acting as Mr. Depp's agent was a question of fact. In his opening brief, Mr. Depp has relied exclusively on his independent contractor theory to challenge whether Mr. Waldman was acting as an agent when he made the statement. He has not asserted Ms. Heard presented insufficient evidence that Mr. Waldman was his agent or that he was acting within the scope of his authority, and those arguments are therefore waived. I agree with this. This is kind of a weird portion here, I guess, because they don't dispute this specific issue in the Depp appellate brief, right? Because when they talk about the independent contractor concept, they're talking about it as a matter of law. That's where they're disputing it. So because of that, it's not preserved as an argument here for them to say, like, yeah, and Amber Heard didn't put up sufficient evidence for this. But that's because they decided to take a narrow approach, which is smart, right? Like I talked about this with Amber Heard's appeal brief was the Amber Heard's appeal brief. How they had like this kitchen sink approach, it seemed more like, right? So they had so many different things that it's kind of hard to focus on, like, what exactly are your arguments. They kind of had, here's how we put it when I was on Rick Hoag's channel with Law and Lumber with Rob. um, we were trying to come up with a descriptor for it, and I came up with it's like a charcuterie board of arguments, right? Because they're not an array of arguments, maybe because there was a dispute between Rob and Rick as to whether an array is could be considered linear or whether it's kind of like smattered around. And so I basically said it's like a charcuterie board of arguments. Um, File that with a chinchilla of evidence and all these other things. Um, Okay. But anyway, we can move on. The interesting thing about this to me is that another concept in brief writing is that basically there's limited resources in terms of real estate on a brief like this, right? So there are page limits for any brief that has to be submitted, whether it's the appellate court or whether it is um at the trial court level or wherever. It's there's always going to be a page limit, right? Because there's just courts have to give some guidelines to attorneys that are going to be put forward. So because otherwise attorneys could just end up filling in like forests of pages for their arguments. So what I'm getting at here is that this is an argument that's not an argument in the appellate brief, and yet this legal team decided to dedicate a lot of real estate to this point that Adam Waldman or that Johnny Depp, his attorneys, did not get into this argument about whether or not Amber Heard provided enough evidence to support the idea that he was acting in the scope of authority. Um, so I'll just show you guys here. And so there's 1 page, 2 pages, 3 pages, 4 pages, 4.5 pages out of a brief that's like, I mean, it's 58 pages in total, but realistically it's like half of that because of all of the citations and everything else. Like the outline that's at the beginning. So uh, okay. And well, I kind of skimmed through this earlier because I was like, this, who cares, right? Because it's not even in dispute. This could have been served very well by a very truncated like paragraph of like, he didn't say it and therefore it's waived, and then citing uh to some case law here. I don't know. Anyway, to the extent the court interprets Mr. Depp's contention that Mr. Waldman is an independent contractor as a matter of law as challenging the sufficiency of evidence on the agency, the circuit court correctly denied the motions to strike. Whether an agency relationship exists is a question to be resolved by the fact finder unless the existence of the relationship is shown by undisputed facts or by unambiguous written documents. And then cites to the case Tingler, which is Virginia Supreme Court case law. And then also McDonald, which is also Supreme Court case law in Virginia, that says whether a person is an employee or an independent contractor is generally a question of fact for the jury. Agency may be inferred from the conduct of the parties and from the surrounding facts and circumstances. I mean, this is true. Indeed, because direct evidence of agency is not indispensable and frequently is not available, circumstantial evidence may be relied upon, such as the relation of the parties to each other and their conduct. Citing to Royal Indemnity Company, which is frequently agencies established and has of necessity to be established by circumstantial evidence. A principal's liability does not turn on whether it directed its agent to take a certain action. Rather, the test of the master's responsibility for the acts of his servants is not whether such act was done in accordance with the instructions of the master to the servant, but whether it was done in the prosecution of the business that the servant was employed to do, and an act is regarded as authorized in the legal sense if it is incidental to the performance of the duties entrusted to the servant, even though it is in disobedience of the master's express orders and instructions. So this is continuing on. Basically my point here is that this is not what Johnny Depp is challenging here. He's challenging the simple idea that an attorney can be considered an employee of a specific client, right? I'm so sorry, I didn't save it, but I did see a question about, Adam Waldman. Didn't he have other clients and stuff too? That was argued in Johnny Depp's appellate brief, right? That was one of the factors that they pointed to say, like, this, Johnny Depp was one of the clients of Adam Waldman. That does not mean that Adam Waldman is employed by Johnny Depp, his client, right? Like, generally speaking, when you are an attorney that is working, um, uh, whether independently as a solo practitioner or whether at a firm, you are, regardless of whether that's a small firm or a big firm, as an attorney, generally speaking, you're going to be an employee of the firm, not an employee of your individual clients that you are serving from the firm. So Adam Waldman, I don't know if he's solo or if he has other attorneys that work for him. But if that's the case, then he probably is technically the employee of his own firm rather than being the employee of Johnny Depp. And that's because uh it's because that's that's how it usually works. um so, but they go through obviously all kinds of policy reasons for why an attorney should not be considered an employee of their client, et cetera, et cetera. Okay, so anyway, all of this stuff, I basically uh I'm going to scroll through because, like I said, this is not even stuff that's in dispute. So why did they spend so much time and energy on it? I'm not entirely sure. Maybe other attorneys around LawTube will have different opinions on this one, and maybe they'll go more into detail on this. And also, I should have said this earlier. Major shout out to Real Laura B for making this available to everybody. So if you want to read the entire brief on your own, I should have also done that in the description, but I didn't. I can put it in the chat right here. Um, Here is the link to it. You can also go to her Real Orbeez Twitter profile for that. She continues to be like one of the top sources, if not the top source, for documentary access for this case. So here, and I'm actually going to pin that so that you guys can see that even if you're coming in late. Okay, so. And I'm going to add that to the description for folks in the replay as well. Sorry, I'm going to do that right now because otherwise I'm probably going to forget. Let's be real. Okay. Okay. Talk amongst yourselves. Okay, cool. It is in the description. So now I don't have to worry about that for later because otherwise, like I said, I probably would entirely forget. Okay, so let's go on to their next point, which is that they say that the court does not need to adopt any rule regarding whether attorneys are independent contractors as a matter of law. They say that this court should reject Mr. Depp's request to adopt a rule that clients cannot be held liable for their attorney's misconduct because they are independent contractors as a matter of law for several reasons. They say there are several reasons why they just shouldn't adopt this. And let me see here. Just want to make sure. Aha. Okay. Here. I was sorry. I was just reading my notes on that. Okay. So they say they have a bunch of reasons why, and so there's like 4 reasons. We'll go through each one. And also I see Stuck on Strings. I see your member chat. And unfortunately I still can't pull it up because it doesn't show up on StreamYard. Says month anniversary, great 3 months. Thank you. Oh, awesome. Yay. Member for 3 months. Thanks so much for being a YouTube member, a member of Bite Club for the last 3 months. Super, super appreciate it. And so happy to have you here. And I hope to see you on Friday for the members only live stream as well. Okay. All right. So let's get into the reasons why they say that this court should not adopt um, Johnny Depp's argument about, this rule about attorneys being independent contractors. First, several courts have held that attorneys are not independent contractors and have imposed liability on defendants for their attorneys' torts. Now, as a general matter, like I said before, this is kind of an issue of first impression, right? Because the Virginia Supreme Court doesn't have any case law apparently on this point. I haven't personally looked to see if there is any, but I would venture to guess that it's probably safe to assume, I should say, that Depp's appellate lawyers here have done a very thorough job in checking for case law. And so, although they're not going to say, they're not going to come out in a brief and say there absolutely is no case law on this. The language that they're going to use on something like that is what they used, which was that we could not find any case law on this, right? Because lawyers are always terrified of making a very absolute kind of statement and then having that uh having that show up and saying like, oh, whoops, we couldn't find any, but there happened to be one. Anyway, and and Secret Mix Squirrel has a member chat as well, saying, "Ooh, I got one as well." Yeah, test it out. If you're a member, test out your member chats. Um, okay, so but remember that because this is an issue of first impression. There's no Virginia case law on it. Johnny Depp's brief was pulling from other states because they're trying to persuade the court where there's this vacuum of case law, right? So that's an appropriate place um to be pulling from other states. That's generally speaking what you should do when there's this vacuum in this particular issue. So obviously, because of that, the Amber Heard's team is also going to be pulling from other states as well to try to persuade against Johnny Depp's points. So first, they've got this Kutso Giannis v BB&T out of South Carolina, and I apologize to all of the Greeks out there if I completely butchered that name. It says so. This is that case held that the defendant can be held liable for its agent's attorney's actions taken within the scope of representation, including possible torts committed by him, and that the trial court did not err by instructing the jury only on agency principles and not independent contractor law. So this is kind of fitting in with the point that they were making before, which are um uh which was that there's not this dichotomy of like, independent contractor or employee, and then they cited to a bunch of out of state case law. This is kind of in support of that point, that they're trying to sort of there's a logical link here to that. um so they're saying these other states over here have said that attorneys can be the link to hold their clients responsible for the things that they do if it's within the scope of their employment. Um, One of the problems here is I looked up this case, I looked up this case, I looked up the next case, and all of these, at least the first, let me look at my notes here. The first three cases, at the very least, yeah, so there's like six cases here. The first three of them are are cases that were about tortious collection practices where the attorney worked for the bank or worked for the lender. And the reason why that's important is because the attorney either is inside counsel or of counsel that's hired by the bank. It means that they're representing the bank in very specific kind of issues. And the thing that the bank got sued for because of the attorney's conduct, it was arguably the thing that was the thing that was done wrong was done by the attorney. And the reason why the bank or the lender was being held responsible is because these are the kind of practices that we really should be holding a bank responsible for, which is tortious collection practices. Um, so it's very squarely in the legal action that was taken that is going to be holding them responsible. Um, if I hope that makes sense. That might be a little bit vague the way that I put it, but or a little bit nebulous. But like the next case. So that's these few cases here. So basically my point is that these are different. These are different from a defamation case, in my opinion. So there's also let's see which one, Nair v. Carter, which is not a malicious prosecution, or not a tortious collection practices case, but it's a case of where there were two allegations in that case: malicious prosecution of civil action, and two, abusive process, which again is basically where the allegation itself is you have undertaken some heinous legal action against me that is improper, that, cost me all kinds of damages, etc. And so therefore I want to hold you responsible. And they're like, well, it wasn't us. It was the attorney that we hired to do this job. It's different. It's different in my opinion. Then finally, they cite to this particular case, Med Informatics Engineering Inc., where they say that the court had accepted as true allegations that an attorney made defamatory statements. Finally, it was about a defamation case, to press on behalf of defendant, and noting that it would be ultimately a question of fact for the jury to decide. So finally down here in this massive paragraph where they cite to a bunch of different cases. Oh, excuse me. I'm okay. They cite to a bunch of different cases before. It's like buried in this paragraph is finally a case that even talks about defamation in the first place. And when you look at it, it's not only is it from out of state, obviously, like I said, we expected that, but it is from it's from a district court that is, not even an appellate court anywhere. So it's not going to be a very persuasive argument. Now, before I get on to the next one, let me point out some member chats here too. Arto Rissanen says memberships are for winners. Get yours now and gift 5 more. We love it. Thank you so much, Arto. Very, very kind of you. And Krista S says, I've got one too. Yes. Awesome. So glad that you guys are using that function. It's fun. And B says, oh no, you're not getting sick, are you? No, I'm not. I think I just have a tickle in my throat here, just from being, I'm just so excited. This is an interesting topic here. Okay. Okay. The next point here says, second, none of the cases Mr. Depp cites involve whether a client can be held liable for his attorney's defamatory statements to the press, and most are distinguishable for additional reasons. So, fun times. Thanks so much for gifting 5 Legal Bites memberships. So kind of you, very generous of you. I see those coming in. Some folks are getting some memberships here. And to all of you guys that are now members of Bite Club, welcome. I hope you enjoy being a member of Bite Club. And I hope that you guys can join us on Friday for our super casual members only live stream. We don't even necessarily talk about law. We just kind of like to hang out and chat. Fun time, says Arto Rissanen told me to. LOL. Thank you. Very kind of you. Okay. So getting back to this, so they throw some shade here, saying that all of the cases that Johnny Depp cites to is they're all distinguishable from Johnny Depp's case here. In other words, they're saying, in this argument where Depp is trying to persuade the court to side with them, there are all these reasons why that authority that they cite to, that is supposed to support their argument, in fact doesn't support their argument, because there are ways that those cases are just different from his, right? And so they go through each one kind of quickly. They go through King v. Dalton, which is in fact Virginia case law, but it is from a district court, so not the appellate court. So King v. Dalton was applying the Fourth Circuit's test for determining employee status, specifically in the context of Title VII and the Age Discrimination in Employment Act, rather than examining vicarious liability for intentional torts. So basically what they're saying is, this was about analyzing a particular case under a very specific discrimination statute. And so therefore it does not fit this It does not fit this situation where we're talking about vicarious liability for intentional torts. That could be a decent argument, right? Because there are ways in which, like, you try to apply a concept in one area of law. um you try to transplant that into another area of law, it doesn't necessarily fit, right? Unfortunately for Amber Heard, I think personally in this particular case, I looked up that case. And I think that, let me see, where are my notes on that? Sorry, give me a second. Oh yeah. So I it lists a number of factors showing why an attorney might not be considered an employee, why an attorney might be considered an independent contractor. And so I think that the reasoning in that particular case, it doesn't rely on the fact that it's drawing from a specific statute. I think it just happens to come out of that statute. So I do personally think that this is the kind of case is that is good for transplanting that logic from that case to this particular one, even though it's coming from the Eastern District of Virginia, right? um okay, so then they go into this case that they had cited to Lynn v. Superior Court. This was a California case that Johnny Depp had cited to, in the underlying brief, saying recognizing that an attorney may act as an employee for his employer in carrying out non-legal functions or business transactions. So in other words, basically they're trying to point to saying Adam Waldman did other non-legal, business transactional kind of work. This defamation piece comes out of that. Personally, I think that this comes right out of an employment kind of relationship. So, and it does appear to me personally as an independent contractor relationship. Um, Then they cite to Plant v. Trust Company of Columbus. So this is out of Georgia, which notes that the attorney was retained for the sole purpose of collecting monies upon a judgment when reaching its holding, that the attorney was an independent contractor, basically saying the scope of this attorney's work was so limited that this is outside the scope. And then they say here, unlike Mr. Waldman, who was retained for several purposes that include litigation and publicity. I don't know if they can actually really reasonably say litigation and publicity, that he was actually hired for those specific purposes, because maybe this was in a filing that I didn't see, because I came into this case a couple months before the trial, so there was obviously a long history for this case before it hit trial. But and I looked through a lot of the filings, but maybe I missed something. I have not seen anything that is uh close to representing the retainer agreement between Adam Waldman and Johnny Depp. And I wouldn't anticipate seeing that either, because that's going to be, generally speaking, privileged, especially, if it's not a thing that is disputed here. Anyway, so I don't know that they can actually say that he was in fact retained for those purposes, because if there was not evidence that was presented for it, um, then I don't think that they can say that. They may have actually even asked him in his deposition about that, and his response to all of those types of questions was, "I'm going to listen to the advice of my counsel, and I will not answer that because it's privileged." So, in which case, again, that leaves a vacuum of evidence. It's not that there is poor evidence, there is no evidence, which is important here. Then they cite to Horowitz v. Hullabird and Root, that says that someone is an independent contractor does not bar the attachment of vicarious liability for her actions if she is also an agent. This once again comes back to the argument up above that I talked about, that conflicts, in my opinion, with the Virginia Supreme Court. Then they cite to Filiberty v. Damon, holding an insurance company was not liable for the acts of its attorneys where imposing liability would make the company liable for actions it could not legally control due to specific New York law. They're trying to say this is because specifically this is out of New York, as opposed to Virginia. So you can't really use this here. But I didn't have a chance to look into this specific case, but if that case says, in other words, like, because they don't really have the ability to control the attorney, the client doesn't really have the ability to control the attorney here. The law likes to tie very closely responsibility with control. The ability to control a certain situation, a certain outcome, means that you should be held responsible for that if that goes wrong. If you don't have the ability to control a particular outcome, why in the hell would we hold somebody responsible for that, for a particular outcome? So yeah. All right. Then they cite to Brad v. West, Brad v. West. I apologize if I'm mispronouncing that, to whoever's last name that is. Says that case, it noted that a party to a civil suit cannot be held liable for the intentional wrongful conduct of his attorney unless the client is implicated in some other way other than merely having entrusted his legal representation to the attorney, which is unlike the facts of this case because Mr. Waldman assists Mr. Depp with publicity as well as legal representation. Again, I don't know if they can actually really say that because of the evidence that is on the record, or more importantly, not on the record. So this is something that they are really sitting on, but I don't know that they really can sit on that. Okay, now the third argument for why the court should not adopt this rule about attorneys as a matter of law being independent contractors. Third, several of the cases cited by Mr. Depp emphasize that imposing vicarious liability on clients for actions taken during the course of legal representation would lead to negative consequences for the legal system, including making parties reluctant to file suit or giving ill-equipped parties the ultimate responsibility over their legal representation and encouraging clients to micromanage their attorneys. These concerns are minimal here, where Mr. Waldman spoke as Mr. Depp's agent to the press outside of the bounds of a traditional legal relationship, and Mr. Waldman's assistance with publicity only tangentially involved litigation. This is a kind of a confusing point, and this is why I highlighted it in a different color, because I wanted it to jump out at me. This seems to conflict with the other arguments that they were making in this particular brief. Now, when we're talking about, and we talked about this throughout the trial as well, that you can make alternative legal arguments, but making alternative factual arguments are usually not going to go so well, right? Like, you want to present the story. This is not a story. This is the story of what happened. You present that to the jury. That's the facts. You can say, here's what the law says that this means. If you don't buy that argument, here's what the law says that this means. Generally speaking, you want to save alternative kinds of legal arguments for the judge. But so when we're talking about the appellate level, the reason why you want to save that for them is because judges are very well equipped to understand the difference between different types of alternative legal arguments. But you still want to maintain a certain sense of consistency throughout a particular brief, right? And so here they were saying, Adam Waldman, when he was making these statements to the press, he was doing what he was hired to do. And he, because we don't have a retainer agreement from him, that details his working relationship with Johnny Depp, but we also don't have any sort of testimony that talks about, what exactly Adam Waldman was hired to do for Johnny Depp. So we basically have zero facts on the record, but we can just assume that that's what he was hired to do. But that's outside the bounds of a traditional legal relationship. So the two put together, they kind of conflict, in my opinion. And so this is a very weak sauce kind of argument. So they're saying here these concerns, the policy concerns for why we should say that attorneys, generally speaking, should be considered independent contractors. Let me pause here for a second and refresh everyone's recollection on what Johnny Depp actually said, or Johnny Depp's legal team said in his brief about the policy reasons for this. Is, it's because attorneys are having to use their independent brain when when they're representing a client. They can't just automatically listen to what their client wants them to do. Sometimes, what a client wants an attorney to do for them is not exactly legal. And so attorneys have their own professional responsibility requirements, and they have to use their independent judgment for representing their client. And sometimes, sometimes even just not even in the realm of like what's legal versus illegal for an attorney to do, just what's smart to do. So the reason why a client hires an attorney is because they want someone who is knowledgeable in this area, in this industry, who is going to have the best kind of judgment for what to do in proceeding with this case or this transaction if it's not litigation. That's the whole purpose, right? And so the attorney has to be able to say, yeah, I understand that you want me to take this sort of course of action in this litigation. You want me to slam all this discovery on on your sibling, in this trust matter because they bullied you your entire life. But that's a majorly emotional kind of response, right? Like that's also, he looks so cute. Hey, Holmesy. Okay. I just saw him. Sorry. Totally distracted. But there are reasons strategically why the attorney will be like, no, that's actually kind of a terrible idea, because here's what you don't know about the legal process that tells me, why this is a terrible idea, and let's go through them. So there's that, and then there's the policy reasons that they highlight here, which is that um we're talking about making parties reluctant to file suit, right? Because if someone thinks that they could possibly be um, held responsible for, for something that their attorney said, eh, yeah, that's added pressure on top of the normal pressures of litigation. Giving ill-equipped parties the ultimate responsibility over their legal representation, when you don't know what the legal process is, like I said, that's the whole purpose in hiring an attorney in the first place. That's not something that we want to be causing here. And then encouraging clients to micromanage their attorneys, which is just absolutely one of the worst things that an attorney can experience on a day-to-day basis, is if they are getting micromanaged by their clients, especially because, like I said, they don't exactly know what's best, right? The attorney is the one that lives, eats, sleeps, and breathes law, for better or for worse. Um, and so having your client micromanage you when they don't really know what is good to micromanage, what is bad to micromanage, it just creates a whole awful sort of situation here. Um, so when we're talking about the communications of an attorney to other individuals, when they are representing their case, whether that's to the press, whether that's to the court, you know, it does present this conundrum that could represent a problem for clients that are being represented by an attorney in a matter that has nothing to do with defamation, has nothing to do with intentional torts. Let's say, for example, you've got somebody who is um, let's take a case that we've talked about quite a bit here. Uh, the OnlyFans murder case, Courtney Clenny. She's going to trial on December 19th. We should be live streaming it if, assuming there will be cameras in the courtroom. I think that there probably will be. Unless something has changed and it's no longer December 19th. But last I checked, it is. So her attorney has made all kinds of statements to the press about her case, right? She's already on trial for murder. Do we also need her, regardless of your thoughts or your opinions about her or about her case? Do we need her also worrying about a potential defamation case because of the things that her attorney is saying to the press on her behalf, or maybe not necessarily on her behalf, but on behalf of representing her as a client, right? Representing her case, representing that, because there often is, as we talk about a lot on this channel, a public relations element to a lot of this litigation. And then obviously there's so the court of public opinion and then the court of law. So this is a case where, yes, there was already a defamation context to the underlying case, but that doesn't limit the possible ramifications of a decision like this on other cases that are not, where the underlying case is not even defamation. Okay. So, so this whole point about Adam Waldman, the fact that his statement to the press was outside of the bounds of a traditional legal relationship, I first off, I don't buy that, because I think that anytime you have someone who has litigation that is being talked about in the press, their attorney is going to make a statement. Alec Baldwin's attorney has been making statements on his behalf. Thank goodness for Alec Baldwin that Alec Baldwin has not been making statements on his behalf lately. But that is relatively traditional in these kinds of contexts. So anyway, their last point is, clients generally rely on their attorney's professional skill and judgment with respect to intricacies of the legal field. In such cases, clients have the ability to monitor whether an attorney's conduct is tortious because they lack legal knowledge. When an attorney speaks on his client's behalf to the press, no legal skills or judgment are involved, and consequently, holding a client liable for his attorney's defamatory statements is warranted. I don't think so. um, this is a weird argument to make, because if you look at the other examples that I talked about, where the attorney is a criminal law attorney and they're representing their client to, talking about their case to the press, yeah, what they're saying is gonna rely on their legal acumen, right? Because you don't want to say something that is going to now prejudice your client. Um, like that can sound like some kind of an admission, some kind of a I don't know. There are so many pitfalls in these kinds of statements that an attorney will make to the press on behalf of their client, that I laugh at this sort of this statement here, this argument that an attorney speaking on behalf of their client to the press is using no legal skills or judgment. Maybe that's not the same sort of, I don't know, like mental activity that you're using in, say, writing a brief or doing an oral argument in front of a judge. But that's still a part of the process of representing your client, and representing your client zealously at that. So I first off, I totally disagree with this statement entirely, um but anyway, let's go on to see what their actual argument here is. Accordingly, this court can assume without deciding that attorneys are independent contractors, and hold that a plaintiff may nevertheless prove a client is liable for the acts of his attorney where those acts are not part of the attorney's legal representation in litigation or do not otherwise involve an attorney's professional skills and judgment. And then it cites to Butcher v. Commonwealth, which is Virginia Supreme Court case law, but it's just talking about the doctrine of judicial restraint. It's kind of a nothing burger here. So if one thing to notice here is, other than that particular bit of case law, that other citation at the very end, which, like I said, doesn't really do much for this paragraph, there is literally zero legal support here for this entire paragraph. There's nothing. There is no case law, no citation to any kind of a treatise, no citation to really anything here at all. So we can basically just discount all of this. I don't think it really requires too much conversation. All right. Now, that's the independent contractor piece. Spent like an entire hour plus on just the independent contractor piece. Um, let's get to actual malice now. So remember, in Johnny Depp's appellate brief, they said, they didn't actually prove actual malice. There was no evidence to prove actual malice. They need to show, Amber Heard's team should have shown actual malice both for Johnny Depp and for Adam Waldman, because when we are talking about vicarious liability for defamation, you have to prove both levels, because Adam Waldman's statement is relying on Johnny Depp's statement, right? So you need both of them, is what they say. Amber Heard's team says no. Let's go through that argument in just a second here. Okay. They say Miss Heard presented sufficient evidence of actual malice. A, Mr. Depp waived any argument that summary judgment should have been granted. In the section of his opening brief regarding actual malice, Mr. Depp asserts the circuit court erred in denying Mr. Depp's motion for summary judgment and motion to strike. Despite this statement, he has presented no argument concerning the summary judgment record and relies exclusively on the evidence presented at trial. The conclusion of this section suggests Mr. Depp seeks to abandon any error regarding summary judgment by omitting any reference to this motion and stating only that the motion to strike should have been granted. So basically what they're saying is they're talking about the motion for summary judgment, and the motion to strike, which these were both motions that were pre-trial. So before there was any evidence on the record, right? And when we're talking about those kind of motions, the judge is going to be looking at, what are the arguments here? What is the evidence that has been exchanged in the discovery process? And is there any chinchilla of evidence that has come out, scintilla of evidence, but I call it a chinchilla of evidence. Is there any bit here that could possibly support the jury deciding against the person that has filed the motion for summary judgment? That's what the judge is going to be looking for. It's the hypothetical could. Now, when we're talking about evidence, or when we're talking about, the jury's actual decision on the back end, we're usually going to be looking at jury instructions. We're going to be looking at, whether a claim should be dismissed outright, because of the fact that the jury does not have any evidence. There's a big fat zero in one of the check marks as to what actually came out in front of the jury in testimony or in any kind of other evidence, documentary evidence, physical evidence, in term to check a certain box for a particular element. So when we're talking about actual malice, this is the important piece in defamation cases against public figures. Both Johnny Depp and Amber Heard had to show in their cases actual malice. Now, in my opinion, neither side explicitly dug into actual malice, but the reason why it works from Johnny Depp's perspective for his claims is because all of his claims were statements that came directly out of Amber Heard's mouth, right? So she would know herself whether she had been abused. She would know herself whether or not this whole thing was a massive stupid hoax, and she's a big fat lying liar who lies. Sorry, I don't mean to body shame. That's not what I meant to do. But you know what I mean? Like, is she a lying liar who lies? So because actual malice is getting at whether or not the person who made the statement knows that what they said was false or is being reckless as to the truth or falsity of the statement. So okay, well, the thought that I was just gonna say, I'll reserve that for a second. But sorry, I often have like two or three of these at the same time. So as it related to Amber Heard's statements, it made sense to say we can, if you believe that she lied, that the statement that she said was false, that is that automatically leads to actual malice, because if you're saying she lied and the statement that she lied in was about something that she herself experienced, she would know. She would know that didn't actually happen. So it it automatically kind of daisy chains actual malice in there. The difference with the Adam Waldman statements is you have a statement that is coming out of not Johnny Depp's mouth, but Adam Waldman's mouth. So Adam Waldman was not there. And so they have to show that Adam Waldman, either they have to affirmatively show that either he knew that what he was saying was false, or that he was being reckless, that he had, no basis for saying this, and so he said it anyway. That could fit into recklessness. So what they're saying here in this in this paragraph, to tie it all back after that really long soliloquy, what they're saying here is that the, at the motion for summary judgment level and the motion to strike level, what the judge is getting at is whether a jury could possibly hypothetically find in favor of the defendant, the non-moving party, who in this case was the defendant. And so here, what Johnny Depp's argument relies on is the evidence that actually did come out at trial. Okay. But let's continue on here. They point to Rule 5A 20E, which requires the appellant's opening brief to include argument, including principles of law and authorities relating to each assignment of error. At the risk of stating the obvious, the rules of the Supreme Court are rules and not suggestions. We expect litigants before this court to abide by them. Failure to adequately develop an argument on brief is colloquially called a bad brief waiver. So in other words, what they're trying to say is what they pointed to, the evidence that actually did come out, is not connected to the evidence or to what they should have been using to argue that the motion for summary judgment and the motion to strike was decided incorrectly. That's basically what they're trying to say here, and they're trying to say, and therefore, because of that, you waive your argument. They say the opening brief contains no argument and no authority supporting Mr. Depp's contention that his motion for summary judgment should have been granted because Ms. Heard cannot prove malice. He has thus waived any error arising from the denial of that motion. Now, I think the next section kind of runs counter to this particular argument. So I'm not going to get too into detail in responding or commenting on this at this moment. In any event, the circuit court properly denied summary judgment. The decision to grant a motion for summary judgment is a drastic remedy, which is available only where there are no material facts genuinely in dispute. And this is true. I mean, this is very solid case law right here. It's right on point. It's like I said, it's got to be a big fat zero. Like you're checking the box of each element of the claim, and there's no evidence to support one particular element or more elements in there. The judge is not supposed to be weighing evidence that's in there to say, yeah, this is not good enough. No jury's going to be convinced by this little bit. That's not the proper position of a judge for a motion for summary judgment. It has to be zero. A grant of summary judgment must be based upon undisputed facts established by pleadings, admissions in pleadings, and admissions made in answers to requests for admissions. In reviewing a ruling on a motion for summary judgment, the court views the record in the light most favorable to the non-moving party. This is, again, all true, generally speaking, for motions for summary judgment. In Mr. Depp's memorandum supporting his motion for summary judgment, his sole basis for arguing Ms. Heard could not prove actual malice was an interrogatory response he described as factually empty. According to Mr. Depp, this interrogatory requested that Ms. Heard explain how Mr. Depp can be held legally responsible for Mr. Waldman's conduct. Ms. Heard had no burden to develop the record at summary judgment. Rather, Mr. Depp, as the moving party, had the burden of proving no material fact was genuinely in dispute. As such, any deficiency in Ms. Heard's interrogatory responses was a discovery matter, which did not warrant granting summary judgment. And this is like, we could get real into the weeds about legal strategy on this kind of stuff, but there are ways of kind of preventing that kind of an outcome, at least in California, in my experience. I don't know if the various mechanisms that are available from what I have done and what I have seen would be available in Virginia based on some specific like discovery forms and things like that. It can be different from state to state. B, standard of review. Ordinarily, when reviewing a circuit court's ruling on a motion to strike, the court determines whether the evidence presented at trial, taken in the light most favorable to the prevailing party, was sufficient to support the jury's verdict. So, again, so this is why Johnny Depp's team spent so much time talking about the evidence that actually did come out at trial here, because it says it's whether the evidence presented at trial, taken in the light most favorable to the prevailing party, was sufficient to support the jury's verdict. So he doesn't just like waive the entire actual malice argument because he's focusing on the evidence that actually came out of trial. Because Miss Heard, because Miss Heard is a public figure, she was required to prove the statement was made with actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not. That is true. Quoting New York Times New York Times v. Sullivan, which is like the premier case that is from the U.S. Supreme Court that everybody cites to when we're talking about actual malice. That's where it came from. And then it cites to the code of, I guess this is the Virginia code. Yeah, of course it is. Duh, we're in Virginia. Hello. Which provides immunity for defamation based on statements regarding matters of public concern that are protected by the First Amendment and published without actual malice. Yeah, we're referencing the First Amendment here because Amber Heard's team likes to reference the First Amendment in this case, and rightfully so. We are talking about speech after all. Whether the evidence in the record in a defamation case is sufficient to support a finding of actual malice is a question of law. Appellate courts have a constitutional duty to exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. So in other words, this is a blank slate for the appellate court here. They don't have to rely on the lower court. The decision by the lower court. This rule of independent review assigns to judges a constitutional responsibility that cannot be delegated to the trier of fact. In other words, it cannot be delegated to the jury. Taken together, these standards of review require the court to view the evidence in light most favorable to Miss Heard when examining the record for evidence of actual malice. Part C. Miss Heard could prove defamation by showing either Mr. Depp or Mr. Waldman had actual malice. This is going to get a little interesting here. There are three distinct bases on which the common law of agency attributes the legal consequences of one person's action to another person: actual authority, apparent authority, and respondeat superior. And then it cites to the restatement third of agency. Now, this is not case law here, right? This is essentially a secondary source that is very useful in giving authority, giving explanations for what really should happen. It's often cited in these kinds of cases, but it's not binding authority here, right? So let's continue on and see where this goes. A principal is subject to direct liability for an agent's tortious conduct that occurs with the scope of his actual authority, while vicarious liability arises from respondeat superior or a tort committed with apparent authority. So, are we talking about direct liability for having actual authority, or are we talking about vicarious liability because of, this apparent authority theory? Contrary to Mr. Depp's contention, Ms. Heard did not rely exclusively on a theory of vicarious liability by maintaining that Mr. Waldman made the statement while acting as an agent. This is because a principal's liability for the acts of an agent is not confined to theories of vicarious liability. I mean, they already said that this is not confined to theories of vicarious liability, but like, why? Ms. Heard was free to argue liability arose because Mr. Waldman was acting within the scope of his authority when he made the statement. That there's nothing in this argument right here that automatically means that they're talking about this direct liability here. Because so they're making this distinction between direct liability and vicarious liability. Direct liability, an agent's tortious conduct that occurs within the scope of his actual authority, not just like authority that he like theoretically might have actual authority. And so again, this relies on evidence being on the record. There being evidence on the record of him actually having certain authorities to do certain things. There is, from my recollection of this trial, nothing on the record that says Adam Waldman had specific authority from Johnny Depp to make these statements. So, you know, it's just not on the record. So how can that support the determination that he actually had actual authority and therefore there was direct liability to Johnny Depp? They're being very impressionistic here, we should say. They're kind of painting with some broad brush strokes in this part, because they're like, yeah, you know, there's direct liability, there's vicarious liability, and here's the restatement, and these are these big concepts, these policies. So I'm not convinced here. So she was free to argue liability arose because Mr. Waldman was acting within the scope of his authority when he made the statement. But there was nothing on the record saying that he had actual authority. There was no evidence of his retainer agreement. He, when asked on deposition, what were you hired to do? He said, I'm not answering that. You know, he said, I'm not answering that. That was the response he got. So there was no response. There was no evidence that came from that. There was a big fat zero. And when it comes to attorney-client privileges, whether that is privileged communications, work product, etc., those are not things that a jury is allowed to infer means something. So they're not allowed to say like, oh, that's an indication that there is some kind of evidence somewhere. No, they're not allowed to do that. Okay, let me move on. Indeed, she tendered, and the circuit court gave a jury instruction entitled Express and Implied Authority, which provided an attorney has the express authority to do everything which the client expressly authorized him to do, and the implied authority to do everything necessary or incidental to the purpose for which he was retained. What was Adam Waldman retained to do? We can say what we think Adam Waldman was retained to do. Have you seen his retainer agreement with Johnny Depp? Have you seen him say anywhere what he was hired to do for Johnny Depp? No? Then you don't have evidence to support that. You can say that's what you think, but you can't say that's what I know because there's no evidence to support that. So this instruction, an attorney has the express authority to do everything which the client expressly authorized him. What did Johnny Depp expressly authorize Adam Waldman to do? Do you know? I don't know. I watched the trial. I don't know. Does the jury actually know? I don't think so, because that evidence didn't come in front of them. Was the implied authority to do everything necessary or incidental to the purpose for which he was retained. I mean, it seems like it seems like what they're getting at here is they're really emphasizing the purpose for which he was retained, emphasis added. Like they're saying, they're now saying, even though they were like, statements to the press are not traditional legal things that a lawyer will do. Um, they're saying that basically this is statements to the press are implied authority to do everything necessary that is incidental to the purpose for what he was retained. We can what they're arguing here is we can basically assume, well, we do know that Adam Waldman was Johnny Depp's attorney, right? He was his attorney. Johnny Depp has a lot of things that he needs attorneys for, right? And they even said, I think earlier in this document that I when I was scrolling past was, he's hired Adam Waldman for a bunch of stuff, including other lawsuits with other people, blah 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 blah. You know, so they can say like, yes, okay, yes, he is Adam Waldman. Adam Waldman is Johnny Depp's attorney. We can say that when you have somebody that you have hired for a specific purpose, right? Because now let me remind you, you can hire an attorney to be your legal utility guy, right? That they handle anything and everything that happens to law or happens in law. Or you can hire an attorney for a very specific purpose. For example, one of the cases that was cited to here was talking about how there was somebody, an attorney who was hired for a very specific purpose of like appearing in court or something like that. I already forgot. But you can have a specific purpose for which an attorney is hired. Any kind of things that are necessary for the attorney to do their job. For example, picking up the phone and responding, to a phone call that they missed from opposing counsel. That's part of their job because that's part of the job of representing an attorney. Responding to an email, filing documents in the court, appearing in court. There are a bunch of tasks that are implied in your representation of your client as an attorney. So this is what they're referring to. What they're saying is Adam Waldman, the act of talking to the press, in this context was an implied activity that was for the purpose of representing him. So, because it is incidental to whatever it was that he was retained to do, which I would agree with that. I would agree that it probably is the case that Adam Waldman was hired for the purposes of representation for this litigation, and that therefore, the statements to the press, probably are an implied aspect of that representation. But we don't know that because we don't have any information on the record as to like what purposes Adam Waldman was hired for. As previously explained, a fact finder could have concluded that the purposes for which Mr. Waldman was retained included speaking to the press on Mr. Depp's behalf or generating negative publicity about Ms. Heard. A fact finder could have concluded. How? What do you mean? Based on what evidence that came out at trial? There was nothing. There was nothing that came out. A principal's liability for the acts of an agent is not contingent upon the agent's liability. So this is talking about direct liability. So they're like I said, this is getting a little bit impressionistic, right? Because they started off referencing vicarious liability and direct liability, and now they've just kind of like smoothly just kind of like shimmied their way into talking about direct liability and saying, like this is kind of sort of a direct liability kind of case, even though there's no evidence on the record to suggest that. A principal's liability for the acts of an agent is not contingent upon the agent's liability. For example, and by the way, I'm not going to disagree with any of this. I'm just going to disagree with this fitting into this particular case. A principal is subject to liability to a third party harmed by an agent's conduct when the agent's conduct is within the scope of the agent's actual authority or ratified by the principal, and the agent's conduct is tortious, or the agent's conduct is that of the principal would subject the principal to tort authority or tort liability. One of the reasons a principal's liability can be independent of an agent's liability is an agent's action may not be tortious because the agent lacks information known to the principal. Otherwise, a principal would hire an agent to make false statements and avoid liability for defamation so long as the agent lacked actual malice when publishing the statements. I mean, I get what they're saying here is that the policy here for this direct liability is like someone can say that they hired someone for nefarious purposes and be like, nope, nope, that was that guy. It wasn't me. I didn't actually hire that person to do that thing. So I don't have, my own direct liability in this, but they might. I don't know, but I don't. Um, like you can see a lot of people kind of like creating this loophole in the law. As Section 7.04 makes clear, Ms. Heard could prove defamation by showing either Mr. Depp or Mr. Waldman had actual malice when the statement was published. Under Section 7.041, Mr. Waldman's conduct is tortious and imputed to Mr. Depp if he published the statement with actual malice. Under Section 7.042, the inquiry is whether liability for defamation would arise if Mr. Depp published the statement, thereby permitting Ms. Heard to rely on Mr. Depp's actual malice to prove defamation. Here, evidence established that both Mr. Depp and Mr. Waldman had actual malice. Okay, let's get into that. Subsection 1. Mr. Depp had actual malice. As the perpetrator of domestic violence on May 21st, 2016, I'm sorry, let's take this seriously. Mr. Depp is aware that he abused Ms. Heard physically, verbally, and emotionally that evening. For that reason, he knows the assertion that there was an ambush, hoax, or setup is false. He also knows that Ms. Heard and her friends did not spill wine or rough up the penthouses because he caused the property damage to the penthouses and spilled wine there on May 21st, 2016. Consequently, there is ample evidence from which the jury could infer that Mr. Depp knew the statement was false or was reckless with respect to its falsity. So, and this is the same point that we talk about with when the shoe is on the other foot with Amber Heard, is that if you were to conclude that the statements that she made were false, the next step is you look at whether or not the sorry, let me go back. So if you conclude that what she said was false, you automatically conclude that she knew that what she was saying was false because she's the one that experienced it. So, what they're saying here is if you conclude that Johnny Depp actually did physically, verbally, emotionally abuse Amber Heard that evening, then him saying that this didn't happen is there's actual malice with that. The same thing with Johnny Depp saying that this is an ambush, a hoax, or a setup, then that automatically means that he has actual malice. The problem is that statement didn't actually come from him. But what they're trying to say here is that this is direct liability. And I mean, obviously, number one, this is these specific pieces that they sort of tease out here about, him being abused physically, verbally, and emotionally that evening, the assertion that there was an ambush, hoax, or setup. Well, the jury disagreed with that too, right? The jury disagreed with that multiple times over. The reason why I say that is because there were two other statements that Amber Heard sued Johnny Depp for that were also by Adam Waldman that were very similar. They were the more generic ones that are like, yeah, no, this is all a hoax. He didn't do it. This is all a hoax. And so the jury disagreed with the proposition that was defamation. The jury also agreed with Johnny Depp that she had defamed him when she implied that he had abused her. So, and I say, yeah, Beast and Common Sense disagreed as well. Yeah, I do agree with that. And so Same thing with, spilling wine or roughing up the penthouses. Um, so this is like, you kind of have to like logically contort yourself for this paragraph. I'm not gonna lie. And that's all they can say about Johnny Depp, because again, an important aspect of this is the statement was not made by him. The statement was made by Adam Waldman, someone else, an attorney that represents him on what? I don't know. Even if it's on this specific case, eh, you have to show that the information that Adam Waldman had uh was well, that he was acting on zero information, or that he had actual knowledge that it didn't happen. Okay. Uh let's continue on. Part 2, Mr. Waldman had actual malice. Mr. Waldman testified that he had no firsthand knowledge of whether Mr. Depp abused Miss Heard, but claimed he saw some things that show her statements to be false. Wow, that seems like that right there gets rid of actual malice. Fancy that. In my opinion, yes, that does. It's in order to defeat actual malice, the defendant just has to show that there is something reasonable for them to rely on to make the statement. This is why, for example, Johnny Depp didn't sue the Washington Post. It's because they had the actual woman who says this happened to me on the record writing the damn article. So I don't blame the Washington Post in this instance. In a lot of other instances, we can blame the Washington Post for a lot of things. But in this specific instance, I don't blame the Washington Post for maybe publishing this article by her, because it's her saying it, right? So it's reasonable for a publication to say, hey, this is the person that says that this happened to them. I think we can probably rely on them. Um, when describing these things with respect to May 21st, 2016, Mr. Waldman testified, so there are 2 police officers, one domestic violence trained female police officer, who testified over and over and over that there was no damage to the penthouse, which Ms. Heard claimed was destroyed. That's a direct quote, destroyed. Yeah. We also saw testimony from the police officers, two of them, 3 of them, I can't remember, but definitely from police officers, saying, yeah, everything was like pretty chill both times, right? There were 2 times the police came by, and we saw the body cam footage. We saw the body cam footage from those officers from those visits on that night, and it showed everything was in order. So there's a lot for Adam Waldman to reasonably rely on if he saw these things, and my guess is he did, because all that got leaked to the press somehow, right? It's reasonable for him to say, um, yeah, like this is something that points to Johnny Depp being defamed. Based on this testimony, a fact finder could have concluded Mr. Waldman believed there was no damage to the penthouses on May 21st, 2016. I mean, they could just say, I don't believe you, I guess. This conclusion would have been supported by the testimony of 3 law enforcement officers who responded to calls to investigate to investigate domestic violence at the penthouses. All 3 officers saw no damage to the penthouses, and the jury could have inferred that Mr. Waldman spoke to these officers or reviewed their testimony when reaching his conclusion that there was no damage to the penthouses at any point in the evening. Yeah, this all supports Johnny Depp. Yet Mr. Waldman told the Daily Mail there was damage to the penthouses. He asserted in the statement, Amber and her friends spilled a little wine and roughed the place up. What? Mr. Waldman could not logically believe both that there was no damage to the penthouses on May 21st, 2016, and that Miss Heard damaged the property to fabricate evidence of domestic violence. The jury could have found that Mr. Waldman's testimony contradicted his belief in the truth of the statement, thereby demonstrating that he knew it was false or was reckless with respect to its falsity. This is bullshit. Okay. What? This is mischaracterizing the evidence that came out at trial. This is mischaracterizing the evidence that came out at trial because this is mischaracterizing because this leaves out some very important points here. This leaves out some very important points here, namely our favorite witness, Isaac Baruch, right? He testified that he saw crap in the hallway. He saw spilled wine. He saw it was a puddle of wine that he walked through. He saw that there were lighting sconces that were torn off the wall. So at the same time, on that night, there both was no damage and then there was damage. That's what happens the night that an event occurs, by the way. This is just I'm sorry. I'm starting to get a little bit amped here, but that is just the nature of events, right? When something happens, immediately before that happens that same day, that thing did not happen. It did not exist. That condition did not exist. And then the thing happened and the condition existed, right? So like I feel like this is like it's like we're getting into psychology here, like Schrodinger's cat, right? The cat is both alive and dead in the box at the same time until you open up the box, and then there's one or the other. But so this is, I'm sorry, the attorneys they're pointing, they're trying to make the best argument that they can, but unfortunately, in order to do that, they have to leave out the very important point that there are officers who went in and investigated after Johnny Depp was supposed to have done this thing, and they said, we saw nothing. And then later, Isaac Baruch came in and he saw stuff. He saw damage. So Adam Waldman, in characterizing after all of these things have happened and characterizing this to the press, is talking about things not happening and then things happening. He says, they called in the cops and that wasn't good enough. So then they roughed up the place and so they created this whole hoax. So he can say that both there was no damage and that there was damage, but that the damage was not done by Johnny Depp. That's the whole freaking point here. Okay. Rant. I'm sorry. I'm getting really amped up here. Okay. So this point of Mr. Waldman could not logically believe both that there was no damage to the penthouses on May 21st, 2016, and that Ms. Heard damaged the property to fabricate evidence of domestic violence. Yes, he could. He could. There was no damage on May 21st, 2016 when Johnny Depp was in the apartment. That was his point. I'm sorry. Okay. Okay. The jury could have found that Mr. Waldman's testimony contradicted his belief in the truth of the statement. They could have found that it contradicted itself. They could have been living in crazy town. They absolutely could have, right? But is it reasonable? No. Thereby demonstrating that he knew it was false or was reckless with respect to its falsity. I'm sorry, this is a dumb argument right here. And I think part of the reason why I'm getting a bit more animated at this point is we're getting into, like, I was so detailed in my reading before, and then I kind of skimmed a little bit afterwards. And so now I this is a little bit of a raw reaction right here. In addition, when making the statement and others as Mr. Depp's attack dog, and when he filed a police report for perjury simply so he could tell the press falsely, in parentheses, that Miss Heard was being investigated for perjury, Mr. Waldman selectively credited only the evidence that he believed was favorable to Mr. Depp and ignored the abundant evidence, the mountains of evidence, right? The mountains and mountains of evidence. The abundant evidence of Mr. Depp's abuse of Miss Heard, including the evidence regarding the night of May 21st, 2016. Therefore, a jury could reasonably have concluded that he either knew his statement was false or was reckless in not knowing and thus possessed actual malice. I'm looking forward to the snark from Ben Chu coming from this section in the reply brief. That'll be very interesting to keep an eye out for. So part 3 is the statement is actionable because it contains a provably false factual connotation. This is the part going into whether the statements are fact or opinion. But before I go into that, Stuck on Strings, thanks so much for the super chat. It says, I feel this whole doc is gaslighting. It's bull caca. The appellate court will see the submitted evidence too. Sorry, silly question. Yes. Yeah. The whatever is on the record, they will have access to it. So yeah, Isaac Baruch's testimony, yeah, all of that stuff, all the stuff, chinchillas and all. Yes. So yeah, this is this last part was just it was it was bad. Mark Fitness, thanks so much for the super chat. Says amped LB is awesome LB. Thank you. Thank you. Okay. All right. So let's turn now to this part of whether or not this was a statement of fact or a statement of opinion. Now, I will admit this part I definitely really only barely skimmed over. So this is going to be relatively new to me. I don't have, research into case law and stuff that I've been able to do on this one. Whether an alleged defamatory statement is one of fact or opinion is a question of law, which is reviewed de novo. So once again, blank slate here for the court to review. In conducting its review, the court does not determine whether the alleged defamatory statement is true or false, but whether it is capable of being proved true or false. That is correct. Part B, the statement is not protected speech. While pure expressions of opinion are constitutionally protected and cannot form the basis of a defamation action, there is no wholesale defamation exemption for anything that might be labeled opinion. Expressions of opinion may often imply an assertion of objective fact, and simply couching statements in terms of opinion does not dispel these implications. That is true. That is true. So I could So for example, you guys know that I'm friends with Rick Hogue. I'm friends with Rob from Law and Lumber. I'm friends with Ian. I could make a statement about like one of any of them and say like, it's my opinion that it's my opinion that Rob is not really a lawyer, not a licensed attorney or something like that, and just say like, but it's my opinion. But that could be a very reckless thing for me to say, right? And I'm friends with him, and people could take that and say that's implying some kind of a factual thing, right? Is he an attorney or is he not? So that's a way that someone could try to say, no, it's my opinion, but it's really a fact statement, right? And for the record, I do not believe that. He's of course, a fantastic attorney, and actually practices out of Fairfax, Virginia. Hey, Rob, if you're watching this, no worries if you're not. Okay. So, factual statements made to support or justify an opinion can also form the basis of a defamation action. That is true. The test for distinguishing pure expressions of opinion from actionable factual assertions is whether the statement contains a provably false factual connotation and is thus capable of being proven true or false. Citing to a Virginia Supreme Court opinion, Fust v. Riverside Healthcare Association, statements that doctors abandoned their patients and that there were concerns about their competence were falsifiable. Okay, yeah, that's a good example. Handberg says statements that a doctor was engaged in excessive billing, sought reimbursement for services that were not authorized or performed, and was opportunistic and aggressive about pursuing money were assertions of fact. Yeah, I mean, because that's those are things that would have happened that would support that kind of assertion, right? something that has happened means that there's a factual basis for it. Gotta fix your bow tie. There you go. And then they cite to Tronfeld v. Nationwide Mutual Insurance, the statement that plaintiff just takes people's money is capable of disproof by evidence if adduced that plaintiff's clients received monetary or other relief as a result of his legal services. The statement, which clearly contains a provably false connotation, reads, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their stories straight under the direction of a lawyer and publicist, and then placed a second call to 911. The assertions in the statement are capable of being proven false with evidence that Ms. Heard and her friends did not call law enforcement on May 21st, 2016, spill wine, rough up the couple's home, fabricate evidence of domestic violence, or contact a lawyer or publicist. And this probably explains why this specific statement the jury actually found to be defamation, whereas the other ones were not. They probably figured the other ones were opinion statements because he's talking about this is a hoax. This was all a hoax. This was, they made this up. They made this whole thing up. But this has arguably, I would agree that there are pieces in here. There are pieces in here that are factual in nature, saying this happened and then this happened and then this happened. It does sound like somebody saying like, I know what happened. But the other statements were much more general. So in which case they probably figured this is opinion. Evidence could also be presented to demonstrate the officers who responded saw Ms. Heard's injuries and property damage, but did not conduct a thorough search. I mean, the jury saw evidence of the thoroughness of their search and saw evidence of their test. I mean, they heard the testimony from the officers saying, yeah, I saw her face and there was nothing there. And then they testified to the actual facts of their search of the apartment. The contention that Ms. Heard carried out an ambush or hoax is falsifiable because Ms. Heard can and did prove Mr. Depp abused her on May 21st, 2016. No, she didn't. She didn't, though, because the jury said otherwise. It's arguments like this that are stupid to me and also misleading because this is not accurate. This is not accurate right here. She did not prove that he abused her on May 21st, 2016. She proved the opposite, right? She failed to prove it. He proved that she had defamed him when she referenced the May 21st, 2016 incidents. So this is not correct. I would anticipate there's going to be some serious Ben Chew snark in response to this, because this goes against what the jury actually found here. And I get that what I mean, maybe what the attorneys are trying to do here with this statement is to sort of like separate the two cases, right? Because technically it was like two cases happening at once, right? There was Johnny Depp versus Amber Heard, and there was Amber Heard versus Johnny Depp. We were all thinking of it as Johnny Depp versus Amber Heard because he was the first one to file. So he technically was a plaintiff there. She was the counter plaintiff. So, we were looking at these cases at the same time, but, we have these two appellate cases that are happening at the same time, but they have different arguments here, right? You've got Johnny Depp's appellate brief that this is responding to. Then you've got Amber Heard's appellate brief that Johnny Depp's going to be responding to. And so it's like, if you look at in order to say that Amber Heard proved Mr. Depp abused her on May 21st, 2016, you have to completely ignore the jury's verdict in the Depp v. Heard side of the case, right? The defamation case that he sued her for. This is looking in a small vacuum at Amber Heard's defamation case against Johnny Depp. And in that universe, there was a win for Amber Heard in that the statement that that Adam Waldman made, the jury said was defamatory. The jury said this statement had lies in it. He made them with actual malice, which I disagree with because there was no evidence on the record to suggest that. And that he made the statement to another person and that therefore there were damages. So in other words, you have to find that Adam Waldman lied. That does not therefore logically mean that Johnny Depp, that the jury believed that Johnny Depp abused Amber Heard on May 21st, 2016. She didn't have to prove in her case, her affirmative case, that Johnny Depp abused her on May 21st, 2016. She had to prove that Adam Waldman had made some lies in his statement to the press. The lies were about, looking back at this statement up here, the lies are talking about lying to the cops, roughing up the place. If there is enough in this paragraph here that the jury theoretically could have looked at this and said, the Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of the publicist and the lawyer. They could point to a portion of this and say, Amber Heard proved that she and her friends, we could say specifically her friends, had no role in getting stories straight under the direction of Amber's lawyer and publicist. They could say, it's my opinion that Amber Heard's lawyer and publicist had no role in telling her friends to get their stories straight. They could say that is the lie here. The lie could have nothing to do with whether or not Johnny Depp abused her on May 21st, 2016. So they cannot say in this brief that she proved Mr. Depp abused her on May 21st, 2016, because that was not something that was essential for her to prove in order for her to win on that particular claim. The inverse, Johnny Depp had to prove that he did not abuse her on May 21st, 2016 in order for him to win, that he had to. That was an underlying thing for his defamation claim because of the nature of the statement that was at issue. So this is an inaccurate statement, whether we are looking at this from the pool that is the Depp v. Heard pool or the pool that is the Heard v. Depp pool, if that makes sense. I don't like the fact that they have this statement in here because it's not correct. And I honestly, like, the more I talk out of my brain right now, the more I hope that Ben Chu just jumps right all over this and says that these attorneys are misleading the court here with this statement because they didn't. She did not prove that. To the extent these phrases are opinions, they are nonetheless actionable because the remainder of the statement sets forth a factual basis that supports these assertions. I mean, I do actually kind of agree with that. I think that the opinion argument in Johnny Depp's brief is probably his weakest argument, and I was kind of like, about this one. But I think that the other arguments in the brief were good enough, in my opinion, to potentially convince the appellate court here. C. Handberg, factual statements made to support or justify an opinion are actionable. So, I mean, yeah, I actually probably would agree with most of what Amber Heard's team argues here in this particular portion. That doesn't mean I think that they should win on this appellate issue. Mr. Depp does not challenge that the statement contains a provably false factual connotation. Instead, he maintains that the context of the statement transforms it into an opinion. When determining whether a statement is actionable, courts examine the statement in context by applying the general rule that words are to be taken in their plain and natural meaning and to be understood by courts and juries as other people would understand them and according to the sense in which they appear to have been used. Yeah, context matters in defamation. Here, the statement makes objective assertions about the events of May 21st, 2021. The only plain and natural meaning a person would draw from the statement is that these events, in fact, occurred. I mean, unless it could be. Now I haven't looked at the article in a minute, but it could be that right before or right after that particular core statement that is cited here by Adam Waldman, it could be that the other stuff that he said right around it shows that he's saying that this is a theory that he believes, right? And that was an argument. Now that I'm thinking about it, back on from the Depp appellate brief, was that they were like, this is a theory that he's presenting, right? This is um a legal theory that an attorney is presenting to explain what his client um is saying in court. So the context can still very much matter in this case for this particular issue, because the context around this specific statement, even if this is very factual in nature, what was said right immediately before or immediately afterwards could say this is all a theory. This is the legal theory that Depp is putting forward. In which case, then that falls into opinion. Relying on Riley v. Haar, Mr. Depp contends that a reader would understand the statement as Mr. Waldman speaking as a legal advocate and offering his own interpretation of disputed evidence. In Riley, the First Circuit observed that even a provably false statement is not actionable if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. That's what I was just describing. While no Virginia court has adopted this principle, it applies only where an author outlines the facts available to him, thus making it clear that the challenged statements represent his own interpretation of those facts and leaving the reader free to draw his own conclusions. Mr. Waldman did not outline the facts available to him in the statement. Although the article notes that Mr. Depp's legal team pointed out the 911 caller on May 21st, 2016 had a female voice, and the Los Angeles Police Department registered Mr. Wright's call at 10:09 p.m., this explains, at most, why Mr. Waldman asserted 2 911 calls were made in the statement. There is no explanation of facts that could be interpreted as supporting the defamatory assertion that Ms. Heard set up Mr. Depp by fabricating evidence of domestic violence. Ooh, I don't know though. Initially I was like, yeah, probably this is like, the opinion argument that Depp's team would lose, but this is not the world's worst argument here by Amber Heard's team, but I will say, if the statement, so that Mr. Waldman did not outline the facts available to him in the statement. The statement is that paragraph that made it to the jury, right? The statement does not include the rest of the context in the article. The article notes that Mr. Depp's legal team pointed out the 911 caller on May 21st, 2016. There was a female voice that called in on the 911 call. These are facts that he's outlining that are available to him. So if I'm going to tell you my characterization of the statement here as it is right now is it seems very fact-based. But when you put it with the context, with the 911 call, with this other stuff that was actually in the article, that can change the characterization of the statement, because it can say, basically what that can communicate is there was a 911 call. The 911 call had a female voice on it. There was the LAPD registered Io Tillett Wright's call at 10:09 p.m. So this is Io Tillett Wright, and then there's a woman who called in as well. There are multiple calls, to 911. These are you could say like I'm thinking like signposts, right? Factual signposts of like facts that are undisputed, right? That these are things that happened. So Adam Waldman is pointing to those in his statements throughout the article and saying, so this is what we believed happened. We believe, because we've got Mr. Wright, we've got a woman, there are multiple calls. Why were there multiple calls? We've got the cops that came and testified. They said that they didn't see this thing. So this is the theory that we have, is that they brought them in, they to try to like make this look like something terrible had happened, but that didn't do the trick. So, so then they roughed things up, before the next one to try to make things like it looks a lot more like a theory if you were to put it in the context of the him talking about these other 911 calls. Especially if now, of course, now this is also a characterization of Adam Waldman's statements in the article. These are not direct quotes, right? They're describing the other points that Adam Waldman had made in this article, in these other statements, right? So now we are not able to see in this specific brief right now, specifically the kind of language that he used. So when he's talking about the 911 call, for example, 911 calls, excuse me, from May 21st, 2016, in the article, the direct quotes that they use of him, is that the same kind of language that he uses here in this statement? Or would the reader be able to detect a difference in the sentence structure, in the way that he goes about, his level of certainty, his, like there are ways to be able to tell the difference between a certain statement when you're talking about one thing versus when you're talking about another. We can't see that here in this brief, but I can definitely point out the possibility that there could be a change from the statement, from him talking about the 911 calls versus what he says here. I hope that makes sense. Okay, let's move on. There is no explanation of facts that could be interpreted as supporting the defamatory assertion that Ms. Heard set up Mr. Depp by fabricating evidence of domestic violence. No, that's not true. That's not true. That's a piss poor argument, in my opinion. Mr. Depp also asserts that courts consider factors such as whether the forum in which a statement is made would cause a reader to understand it as the author's opinion, the degree to which the audience is familiar with the underlying facts, and the identity of the speaker. Each of these factors suggests the statement is not an opinion. Okay, so factors here. Whether the forum in which the statement is made, the forum meaning this is a statement made to a journalist, the degree to which the audience is familiar with the underlying facts. So the audience that is either, and there's two hypothetical audiences here, right? There's the journalist that he's directly speaking to, and then there's the reader of the article itself. Either way, you have a journalist that is gathering the facts of this and then writing this article. And then you have the reader of the article who is seeing all of the statements and all of the facts about the case that are being written about in the article. And then the identity of the speaker. So Adam Waldman as the attorney of Johnny Depp. Each of these factors suggests the statement is not an opinion. Okay, let's see why. The Forum is the Daily Mail, a widely circulated tabloid that publishes newsworthy accounts of factual events, not opinion pieces. The overwhelming majority of the Daily Mail's numerous readers are not familiar with the underlying facts of Miss Heard's abuse. And the identity of the speaker, okay, hang on. So they're saying that because this is like a normal article that's written up and not an opinion piece. The reason why they want to make this point is because Amber Heard's Washington Post article is an opinion piece, right? That's what they labeled it as. That is technically what it is. She's not a normal like a correspondent who works for the Washington Post. This was just a one and done kind of thing. And so yeah. So but that is not that's not okay. That's not enough to show that this is a statement of fact and not an opinion. You can have plenty of factual journalistic articles that include statements of opinion by people, right? Like that can be the story that you're writing about. So okay. Anyway, let's move on. And the identity of the speaker, as Mr. Depp's attorney suggests, he has inside knowledge or access to evidence that establishes Miss Heard's allegations are false. Um, I would argue that the identity of the speaker as Mr. Depp's attorney suggests that he is going to frame things in a way that is most beneficial to his own client. It's not his job to necessarily inform the entire world about the actual facts of like objectively what happens, right? Like he's a hired gun. Everyone knows that. Everyone knows that Elaine Bredehoft and Ben Rottenborn were hired guns for Amber Heard. Like they're not putting themselves out there as like, oh, we're here to inform the world of this objective truth. No, they are there to do a specific job. They are there to represent a client zealously. So I completely disagree with this argument here, saying that the identity of him as his attorney. I mean, it suggests he has inside knowledge or access to. I mean, sure, yeah, but he's going to present that evidence in a way that is not objective. No one who in their right mind would expect an attorney representing their client to present facts or theories or anything having to do with the case in a way that could be interpreted as like against the interests of their client. No, that's stupid. While a reader might consider statements an attorney makes in court as mere advocacy, the press is not the traditional forum in which attorneys advocate for their clients. That's such a dumb argument. I'm sorry. That's a no. I mean, I'm getting very opinionated, but the attorneys that actually wrote this has to be the best argument that they could come up with, and I don't besmirch that, right? Because they have a job to do, and so they've got to do the best that they can, right? But it doesn't matter that the press is not the traditional forum in which attorneys advocate for their clients. The traditional forum, I mean, we could definitely have a whole discussion on the traditions of attorneys, who are representing clients that are being written about in the news and their statements to the press. If this was not really a traditional forum for attorneys to be representing their clients, and yes, it's not the core, place where an attorney goes to represent their client. It's not like, oh, we're going to file a case with the press. No, but if this was so removed from what an attorney does, here's just this may not make any difference to you, but I often reference movies and shows and stuff like that. But think about the movie Chicago. That was all about the razzle dazzle of trial, right? A trial attorney putting on a show for the jury and the press. There were whole numbers that were dedicated to the criminal defense attorney putting the story in front of the press and having the press, eat up his framework. So and that's supposed to be set in I don't know what, 1920s, 30s. I don't even remember. It would have to be the 1920s. Yeah, because it was, yeah, I'm pretty sure like 1920s. Anyway, so and obviously there are so many ways that Chicago, the show, the movie, that diverges from real life. But there the basic essence of it is that there is this relationship between high profile trials and the press. Now with social media. So if you want to ignore that, that's fine, but that's just not reality. In sum, the context of the statement does not transform its factual assertions into opinions. For this reason, the circuit court correctly denied the motion for summary judgment and motions to strike the evidence. Okay, part 4. The circuit court correctly rejected the proposed jury instructions on independent contractors. Okay, so now we're back to independent contractors here. Part A, standard of review. The decision to deny a jury instruction rests with the discretion of the trial court and will not be reversed absent an abuse of discretion. So this is a good point right here. So absent abuse of discretion. So this means that the appellate court, in analyzing this specific issue, has to give quite a bit of weight to the trial court here, because they're going to be looking for whether or not she abused her discretion in making this decision. The sole purpose of appellate review of jury instructions is to see that the law has been clearly stated and that the instructions cover all issues which the evidence fairly raises. Whether the content of the instruction is an accurate statement of the relevant legal principles is a question of law that, like all questions of law, is reviewed de novo. Where other instructions fully, so in other words, the question of whether this jury instruction accurately states what the law is, that's a de novo principle. So in other words, this court is going to look at that specific like sub issue from a blank slate. Where other instructions fully and fairly cover the principles of law governing the case, the trial court does not err in refusing an additional instruction on the same subject. Makes sense. Part B, the jury instructions fully and fairly covered principles of agency. As previously explained, the concept of an independent contractor does not apply to this case because Mr. Depp's liability stems from Mr. Waldman's role as his agent when speaking to the press. And even if Mr. Waldman is an independent contractor, it does not preclude Mr. Depp's liability for his conduct. I mean, again, so it seems like they are about to rely heavily on this argument that is pretty flimsy, in my opinion, right? Because this is going all the way back to over an hour ago when I explained that what they were using as authority was all persuasive law from outside of Virginia, and it seems like it conflicts with the Virginia State Supreme Court. So this is already going into this section. It looks like they're about to rely pretty heavily on this concept that is it's on some stilts. And let's say the stilts are maybe on a cliff, and not that solid. Therefore, proposed jury instructions 22, 23, and 24, which concern independent contractors, are not accurate statements of the relevant legal principles and were correctly refused. Additionally, the refused jury instructions on independent contractors overlap with the given instructions on agency. Jury instruction TT defined a principal and agent. Okay, so give me a second. Okay. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. An agent is a person who is subject to the power or right of a principal to control the means and methods of performing the work. Proposed jury instruction number 22 effectively defined an independent contractor as opposite of an agent. An independent contractor is a person who is engaged to produce a specific result but who is not subject to the control of the employer slash principal as to the way he brings about that result. If you find that Mr. Waldman was acting on Mr. Depp's behalf, but was not subject to Mr. Depp's control as to the manner, method, and or means by which Mr. Waldman worked, you must find that Mr. Waldman was an independent contractor. Sorry, give me a second. I've got to go back and reread these. Okay, so this is the jury instruction that was allowed, talking about principal and agent. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. So that would be, if we are talking about the principal and agency relationship. If you think that Johnny Depp, if there's an agency relationship, Johnny Depp would be the principal, Adam Waldman would be the agent. An agent is the person who is subject to the power or right of a principal to control the means and methods of performing the work. Means and methods of performing the work. So by this definition, Adam Waldman doesn't fit the definition of an agent, because the means and methods of an attorney's work, generally speaking, are not controlled by the client. That just runs counter to every single experience I've had as an attorney, representing clients. So proposed jury instructions. So this is what Johnny Depp wanted to have introduced to the jury. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way he brings about that result. That this is true so far. If you find that Mr. Waldman was acting on Mr. Depp's behalf, but was not subject to Mr. Depp's control as to the manner, method, and or means by which Mr. Waldman worked, you must find that Mr. Waldman was an independent contractor. That is true. This is correct. This is correct according to the law. Yeah. Both instruction TT and proposed jury instruction number 22 explain that liability depends on whether Mr. Waldman was subject to Mr. Depp's control with respect to the means and methods of his work. In light of this redundancy, the circuit court did not abuse its discretion by refusing proposed jury instruction number 22, citing to Hauser, courts may refuse additional instructions on the same subject as given instructions. But this one is much, I don't know. I mean, there's some overlap, but it's not exactly the same thing though. But also, I mean, they took pains to explain the difference between the principal agency direct liability and the independent contractor uh vicarious liability earlier. So I don't yeah, I don't know. No, I can see these still fitting separate buckets. Additional instruction on the same subject. I don't see these as exactly the same subject here. Anyway, moreover, Mr. Depp suffered no prejudice due to the refusal of proposed jury instruction number 22 because he was free to argue that based on jury instruction TT, he was not liable because Mr. Waldman was not his agent. Okay. See code section 8.01-678 prohibiting reversal for harmless error. I mean, that's true. The jury could have looked at that instruction and said, I don't think that there's any evidence that Johnny Depp controlled Adam Waldman. So, because here's the thing, when it comes to stuff like this, discretionary, this one, if there was an error, it has to be reversible error. If it was harmless, in other words, if it was the kind of thing that is like, yeah, technically the court got it wrong, but did it actually make a difference in the result? Would it have made a difference to the result? Could it have made a difference to the result? If not, um, then it's something uh then it's not something that the court is going to reverse on. And then it says to Campbell v. Campbell, a mistake of law made during the trial process is harmless error unless it prejudiced the appellant. Yeah, no, I mean that's generally going to be true. Proposed jury instruction number 24 is duplicative with the given instructions on the burden of proof. Jury instruction 20 provided Ms. Heard has the burden of proving by the greater weight of the evidence that Mr. Waldman was an agent of Mr. Depp and that Mr. Waldman was acting within the scope of his agency when he made the statements. Okay. See also R21506 explaining jury should return a verdict in favor of Ms. Heard if she proved Mr. Waldman was acting as an agent when he made the statement. Proposed jury instruction number 24 states a person who hires an independent contractor is not liable for the independent contractor's actions. If you find that Mr. Waldman was an independent contractor of Mr. Depp instead of an employee, you may not find Mr. Depp liable for Mr. Waldman's conduct. The jury instructions on the burden of proof adequately explained that Mr. Depp's liability turned on proof of agency. Giving an additional instruction providing Mr. Depp was not liable if Mr. Waldman was an independent contractor defined as the opposite of an agent would have been duplicative and unnecessary. See Hall v. Commonwealth, noting it is not desirable to multiply instructions and finding duplicative instruction was properly refused. Proposed instruction number 24 also expresses the same false dichotomy discussed above by asserting the jury may find Mr. Waldman is an independent contractor instead of an employee. This assertion would have confused the jury by indicating Ms. Heard was required to show Mr. Waldman was Mr. Depp's employee rather than his agent. And finally, the circuit court did not abuse its discretion by refusing proposed jury instruction number 23 because giving it would have invaded the province of the jury. It is fundamental that the court must respond to questions of law and the jury to questions of fact. Okay. Whether a person is an employee or an independent contractor is a question of fact for the jury. Yet proposed jury instruction number 23 stated an outside lawyer retained by a client in connection with litigation is an independent contractor. This instruction would have directed the jury to automatically conclude that Mr. Waldman was an independent contractor, thereby usurping the jury's role to decide this question as a matter of fact based on the evidence presented. At a minimum, this instruction would have improperly singled out for emphasis a part of the evidence tending to establish a particular fact by highlighting Mr. Waldman's role as an attorney. Okay. Yeah, I mean this is definitely getting a bit more into the weeds, and so I don't know. I mean the jury instructions, that was in my opinion one of the weaker parts of Depp's brief. Part 5, the circuit court did not abuse its discretion by requiring redaction of irrelevant and inadmissible portions of the article containing the statement. This is the context argument. Let's see what they have to say about this. Decisions regarding, so first off, a standard of review. Decisions regarding the admissibility of evidence lie within the trial court's sound discretion and will not be disturbed on appeal absent an abuse of discretion. A court has abused its discretion if its decision was affected by an error of law or was one with which no reasonable jurist could agree. Okay. So yeah, this is a high hurdle for Team Depp to cross over in this particular one. Now, this is going to be this is the last argument in this reply brief. So here we go. Part B. The redacted portions of the article were inadmissible. The circuit court properly excluded the contents of the full article that contained the statement because it constituted inadmissible hearsay and was not necessary for the jury to assess whether the statement was defamatory. Okay, so they say the pieces that Johnny Depp's side was saying that was necessary context was inadmissible hearsay, and it wasn't necessary for the jury to assess whether it was defamatory. Okay, well, I don't know. Let's see. For the purposes of the third assignment of error, the court need focus only on the statement that the jury found was defamatory toward Heard. Mr. Depp argues that the full text of the article was necessary for the jury because it would have shown the statement was not actionable defamatory comment. As explained supra in section 3, meaning up above, the statement was plainly defamatory and was not protected speech. Moreover, Mr. Depp presents no argument or evidence other than his own conjecture that anyone reading the article would have understood the statement as anything other than a statement of fact that Miss Heard and her friends lied about Mr. Depp's physical abuse and property damage on May 21st, 2016. Okay. I mean, they have to argue from the standpoint of what a reasonable person would read. So I don't particularly buy this argument. The fact that the article contained a quote from Ms. Heard's lawyers, additional statements by Mr. Waldman on behalf of Mr. Depp that were factual in nature and references to the parties' ongoing dispute does not and cannot remove the defamatory sting of the comment. Well, I would agree. I would argue otherwise, because these other statements that are factual in nature are things that that would have given context to the statement that is at issue. So, sorry, let me rephrase that. The points up above in this brief where we were talking about the 911 calls, the fact that it was I will tell it right on one and then a woman's voice on another. Like these are points that that were contextual points in the article that did not make it into the statement. So those are definitely statements in there that would fit into this, like should this have come in or not, right? Statements like that. And then there's more, obviously. So does that do the points about the 911 calls change the character of Adam Waldman's statement? I think it definitely could. It definitely could, based on what we were reading earlier. Obviously, we didn't see the direct quotes, but the fact that they didn't use the direct quotes means that, in my opinion, it probably means that they didn't want to use directly what Adam Waldman said, because that probably would show, yeah, that kind of definitely gives some context here. They're gonna frame this in various ways, so that it is better for their argument. And at the same time, those are facts that Adam Waldman had talked about in other statements that are connected to this particular statement, that are factual, that the reader would have read, right? We have to assume that this is that the statement that the readers of this article didn't read this statement in a vacuum. They read it in the context of this entire article. So the other factual points that they would have been reading along the way would have helped to inform them as to what Adam Waldman was saying, to inform them as to whether they thought that it was a lawyer representing his client and putting forward a theory of the case, or if they thought that this was a lawyer informing the public objectively about the truth. As the circuit court noted, whether or not the statement is defamatory cannot depend on a third party's decision to put the statement in a certain portion of the article. This is because, as the circuit court correctly ruled, at the time the statement was made, Mr. Waldman didn't know what the articles were going to say or how they were going to print the article. Well, I don't exactly agree with that because, again, this, I talked earlier about how the law tends to put a very strong connection between someone having responsibility for an outcome and someone being able to control that outcome. So this is a situation where Adam Waldman obviously had zero control over where these statements ended up pieced together in this article, and if they even made it into the article in the first place. So his statement in that article, I mean, that's even more reason why this should not be defamation, which is very different from Amber Heard's case, right? Where the op-ed that she wrote was written by her, panned over how many times between her and whoever else at the ACLU. She had full control over how her words were placed on that page. Adam Waldman had zero control of that. Johnny Depp certainly had zero control over how Adam Waldman's words were placed on a page by some other journalist at the Daily Mail. So that's even more of a reason, in my opinion, as to why he should not be held liable for defamation for how this journalist decided to put these various statements together. However, that also, sorry, maybe not however, but at the same time, that also uh, is even more reason to me to include all of these other things that Adam Waldman said to this journalist that made it into the article, because those could have helped to inform the context of what he was saying. Because it could very well be that this journalist took this out of context and spliced things up in different places. That's not Adam Waldman's fault. That's not his fault. That is the fault of the journalist. This is some Taylor Lorenz shit that we're talking about, right? Like there are journalists that have been accused of this kind of stuff time and again, and people have gotten very upset about this kind of stuff, justifiably so. Um, so to then on top of that say that somehow Adam Waldman, despite the fact that he has no control over where these pieces are placed in the article, that it's like, too bad, so sad. Your statement has been spliced up by somebody else, and we're not going to allow any context into to allow you to give context, so that the courtroom, the jury can at least see everything that the jury saw, or that the reader saw. I don't know. I mean, I'm this is I'm not, my thoughts right now are kind of being patchworked together in real time, because this is we're towards the end of it, and of the brief, and I hadn't read this portion yet. So I'm kind of putting this together in real time, but all of this points to me to allowing the context in. This ruling was not an abuse of discretion. Now this, yeah, they might have Johnny Depp on this part, but let's see. Trial courts will have to decide on a case-by-case basis whether an unredacted document containing both actionable statements of fact and statements of mere opinion should be presented to the jury for purposes of providing context for the actionable statements of fact, or whether only the actionable statements of fact should be presented for the jury's consideration. Yeah, okay, sure, but whether this was an abuse of discretion depends on whether that has an ultimate impact to the jury. And if we're gonna analyze that, we need to see the rest of the statements that Adam Waldman made in that article. Mr. Depp's reliance on Shaker v. Bufault is misplaced. Contrary to Mr. Depp's interpretation, Shaker simply stands for the proposition that a court may consider the alleged defamatory comment in the context of a longer statement by the same defendant for the purposes of determining whether a statement can be reasonably understood as stating or implying actual facts, whether those statements are verifiable, and whether they are reasonably capable of defamatory meaning. These are all questions of law for a court, not factual questions for a jury. In Shaker, the Supreme Court considered the defendant's full emails because, read in context with the words from the same defendant, the alleged defamatory statements did not contain sufficient defamatory sting or constituted protected opinion. The other thing here, though, is that if I remember correctly, I think that Adam Waldman's statements were also supposed to be in response to Amber Heard's attorney's statements. I don't know if that's fully accurate. I can't exactly remember, but if that is the case, then they absolutely should have allowed statements made by Amber Heard's attorney in as well. Because if the journalist told Adam Waldman, "Hey, this is what they said. Do you have any comment on that?" That would be important context, even though it's from a different person and not Adam Waldman. Mr. Depp cites no case that takes the stance he now asks the court to adopt, that the defamatory nature of one person's statement quoted in an article may somehow be cleansed by the statements of others quoted in the same article or statements of the author of the article itself. The circuit court properly excluded this other commentary because it was inadmissible hearsay and because it was not relevant to the jury's inquiry. This includes the additional statement from Mr. Waldman that Miss Heard and her friends' alleged hoax didn't have the desired effect because it does nothing to change the meaning of the defamatory statement. I don't know about that. I don't know about that. So they're saying that he didn't cite to. I mean, okay, sure. They can say that he cites to no case that takes on this specific position. That's entirely possible, but that doesn't necessarily mean that it's not good reasoning and that he's not relying on good case law that supports his position. And unlike the statement in Shaker that the court found was protected opinion because it was based on facts that themselves were not alleged to be false and defamatory, the statement itself was a factual statement involving Miss Heard that the jury found to be false. Nothing about the rest of the article could have changed the correct determination by the jury that Mr. Depp's statement through Mr. Waldman in that article met the elements of defamation. I mean, as we discussed above or earlier in this article, in this video, I disagree with that. Finally, Mr. Depp's suggestion that the full articles were necessary for the jury to assess Heard's damages is wrong. The remainder of the articles simply discussed fragmented aspects of the ongoing dispute regarding Mr. Depp and Miss Heard's relationship. And the jury was presented with far more details of the relationship through the evidence permitted at trial, albeit an incomplete picture due to the court's improper exclusion of much of Miss Heard's evidence by abuse by Mr. Depp. Okay, I mean that's their position. They've got to make their position. They've got to make that clear. And the jury was presented with evidence of the ways in which Miss Heard had been damaged by the statement, both from Miss Heard herself and from dueling damages experts. Thus, to the extent that the circuit court erred in excluding the contents of the article that contained the statement, any such error was harmless. Citing to Haas v. Commonwealth, noting that a reviewing court must consider the potential effect of the excluded evidence in light of all the evidence that was presented to the jury. There is nothing that the remainder of the articles could have added to the evidence regarding damages that was presented to the jury. I don't exactly agree with that because the damages, I mean, we're referring to her loss of reputation. Did the thing that Adam Waldman said here, was that the thing that ruined her reputation? Was it maybe all of the details that were being written in that same damn article that maybe ruined her reputation? I don't know. I don't offhand agree with what they're saying here. Conclusion: for the foregoing reasons, Miss Heard respectfully, she's always respectful, respectfully requests that the aspect of the judgment of the circuit court at issue in this appeal be affirmed. Okay. And this is signed off by Ben Rottenborn, counsel for the appellee. All right. So, and that's it. That's the thing. As a reward for you guys for getting to the end here, I'm going to give you a closer view of Holmesy. Hey, buddy. Oh, I know you're so sleepy. Come here. I gotta show everybody your bow tie. Oh, yes. Look at this guy. Wait, no. You gotta sit right here. Oh, come on, show your bow tie. Look at this thing. It's so cute. I love it. He's so not amused right now. Sorry, buddy. I know you're sleepy. Okay, you can go, I guess. Oh yeah. Wait, but just sit right here. Just do that thing right here so that people can see you. Okay. Well, anyway. All right. Well, I guess he just really doesn't want to show his bow tie. Okay. Anyway, this has been wonderful. Thank you guys for sticking it out with me. That's not a ghost. That's Indy behind the curtain. It's also not the Wizard of Oz. It's definitely Indy. She's been snoozing. Okay. This has been great. I think that overall, it's not the world. Like I was very critical of this document, but I think that overall, it's not the worst appellate response brief that I've ever read before. It's not the worst argument that we've seen coming from Amber Heard's team. I still think that Johnny Depp's side has the stronger argument in most of its places. There are some here and there that the court might agree with Amber Heard's side, but I think that there were some parts that I specifically did not like. Right, like there was the characterization that Amber Heard proved that he had abused her in 2016. Not correct at all. So definitely not correct at all. So okay. Thank you everyone for joining me. Thank you so much for everybody joining the chat. Thanks to the folks that joined as members today as well. Reminder, it is a wonderful thing to have support from folks like you through YouTube memberships or locals or Patreon, so that I can decide to talk about whatever kind of cases that I want to talk about, including things that get demonetized, like the OnlyFans murder case, because sometimes YouTube does not like the spicier topics, but we got to talk about them, right? These are interesting cases. And thank you, of course, to everybody that super chatted. And of course, thank you to the mods for always providing a lovely space, and making sure that the things stay. We try to keep it classy here, even when we're agreeing or disagreeing with other people. So alrighty, with that, we're gonna have some uploads coming up this week as well. A couple uploads this week. One tomorrow, so keep an eye out for that, and then one I think the next day. Okay. All right. That for me about does it. See you in the next video.